Well, hello everyone, and welcome back to Uncivil Law, where as always we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. We are continuing with part 2 for the day of the ongoing James Crumbley trial. Ethan Crumbley, his child, committed a mass shooting at the Oxford High School. He is charged with involuntary manslaughter. The essential theory being that he recklessly provided a firearm to a person who was mentally troubled and willfully disregarded a known and foreseeable risk to others, ultimately culminating in his son shooting and killing 4 and harming others as well. The most problematic element of this from a legal perspective for me is the foreseeability element, because it seems difficult to be able to foresee the incident that occurred. That's a lot of foreseeability, especially if you read the Court of Appeals, where they seem to indicate the relevant standard is whether or not they could foresee it on the day in question, not an issue we saw raised with the jury instructions in Jennifer Crumbley's trial, but yet to be seen whether or not it's an issue raised here. And we have so far heard from one of the teachers who was shot, as well as a person who was then at the sheriff's office, who now works for the Secret Service, but who is an expert in retrieval of computer data and cell phone data and analysis of cell phone tower location information. So he went to the school in the day in question, initially because there was sort of an all-hands call, so he kind of went there because everyone did, and then was the person who was most responsible for the retrieval of information from the school system that helped to document the incident, and of course also from the cell phones of the perpetrator as well as these defendants as well. Cell phone data related to that, so all that good stuff. So that is where we're sitting, and we are just waiting for the jury to come back. So I assume that we'll hear a trial much like we heard in Jennifer Crumbley's trial. So I imagine we're going to hear from a couple more witnesses to document the homicide, which of course is an element of the crime. This is involuntary manslaughter, so you got to prove the homicide. It's true that they could stipulate to it, but the prosecution obviously doesn't want to, because they want the jury to have to confront the horror show, because it will ramp their emotions up. So, and make them really pissed. So we're in that phase. So I would expect to hear from 2 or 3 more witnesses, possibly today, on the issue of the homicide, and then we'll hear from some other witnesses testifying to other elements of the crime.
22279-989
Cindy Marquis on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Mario Wayman on behalf of James Crumbley, who is standing to my left.
You may be seated. We had an argument yesterday evening about numerous exhibits. A number of exhibits were allowed in, some were excluded this morning. The question remaining about People's Proposed Exhibit 133 and People's Proposed Exhibit 153. People's Proposed Exhibit 153, we heard an argument about it's the court's ruling that this exhibit does not qualify under any hearsay exception. It's the same ruling and for the same reason that Exhibit 118 was excluded. And then as it pertains to Exhibit 133, broke this exhibit down into 2 parts. The first one is the Tuesday 10 a.m. I have to go to my kid's school. Counselor just called. This is what I'm dealing with. I'll be back by 11:30 to 12 the latest, with a picture of the math homework. And that was a text between co-defendant Miss Jennifer Crumbley and her friend. And I don't find this text relevant to the case of James Crumbley. So I'm going to exclude it, except the prosecutor may raise it if it's necessary for some reason in impeachment, such as chronology or a knowledge issue. So if it's necessary to impeach some other evidence submitted, I'd reconsider that issue. With regard to the bottom part of this exhibit, again, plaintiff's exhibit 133 on Tuesday at 1:23 p.m. As an offer of proof, and the prosecutors indicated they'd be able to demonstrate that there was an active shooter alert, and that subsequent to that, the defendant is calling his wife, Mrs. Crumbley, from their home, and that while Mrs. Crumbley is on the phone with her husband, she is texting her friend, presumably under the influence of the startling event, that there's an active shooter in the school, that Mr. Crumbley is at the home, she's on the phone with Mr. Crumbley, and contemporaneous with her conversation with Mr. Crumbley, she texts, "The gun is gone and so are the bullets, and OMG, Andy, he's going to kill himself and he must be the shooter." So I'll be allowing those text messages in pursuant to 803.2.
Thank you, Judge.
Thank you, Your Honor.
So, are you ready for the jury?
Yes, Judge.
All rise for the jury.
All right, you can read it. Mr. Everett, so you are separate. All right, go ahead.
Thank you. Sir, we were talking about when you arrived at Exeter High School on November the 30th and you went to the security office.
Yes, sir.
Okay. And tell us again, what was your primary responsibility at that point in time?
Was to try to secure the video of what had happened in the hallway where the shooting started.
And you said that there were a number of cameras operational at Oxford High School at that
Yes,
time?
yes, there was.
So, in securing the video, what specifically were you asked to do?
We weren't really asked to do anything. I assumed what the bosses, the sheriff and the undercover, all them would want to know is where it started. We knew it started in the 200 hallway, and we saw as the shooter came out, but we were trying to figure out when he went into the bathroom.
So what did you do to accomplish this goal?
The shooter came out of the bathroom with a black coat on. We kept on, rewinding 5 minutes, 10 minutes, 15 minutes, and watching all the way through, looking for him to go into the bathroom. And we didn't know the shooter's name at the time. Then we could never find somebody going into the bathroom wearing what the shooter had when he came out. Somebody told us what his name was. And so we knew that he was in the counselor's office earlier in the day. So we went all the way back to the time he was coming out of the counselor's office to determine what he was wearing before he went to the bathroom. That's how we were able to figure out when he did go in.
Okay, so you were able to eventually identify the shooter?
Yes.
Now, are you the person who actually synced together the camera footage for other investigators?
Yes, it was.
Okay, and tell me, how is it that you were able to do that?
with over 100, at least 100 cameras in the school, you just take clips of each one. As they move from one camera, you go to the next camera and save that section, and then there's software that I use to just thread them all together.
And then you testified earlier that you were aware that the shooter was in his counselor's office. Were you also aware that James and Jennifer Crumbley were at Oxford High School that day?
At that time, yes, I was. Yes, I'm sorry.
And eventually, were you requested to obtain as much surveillance video footage from that point in time as you could?
Yes.
Your Honor, I'm going to object to leading.
It's just a foundational job.
All right, Sistine.
Now, in the immediate days after the shooting, what was your primary responsibility with regard to the video?
Different things came up. There was a rumor going around that the shooter had actually tried opening doors, and identifying himself as the police. Well, that was actually the police, but I had to go up there and get more video footage just to determine how far he went completely down the hallway before he turned around, and then what had happened in the surrounding hallways and such like that.
And as the investigator who had to sync together the video, did you have to watch the video of the shooting itself?
Yes, sir.
All told, how many hours of video do you think you watched to put this together?
Too many.
How many different angles did you have to see this from?
Every angle, every camera. There's some cameras that pointed back in one direction from where it started to, I don't know, 7 different angles maybe at different times.
In part of putting that footage together, were you aiding in the identification of the victims?
Yes.
Tell us what you saw in the video.
Started at 12:51. The shooter came out of the bathroom. I'll never forget it. He came out of the bathroom like what I've referred to before in my life, like a proud chest, like his shoulders were back. And he comes out of the bathroom, and there's Phoebe and her boyfriend just standing right there. And he takes the gun as he comes out of the bathroom, and he turns and levels the gun and fires at Phoebe and hits her in the shoulder and fires at her boyfriend, hitting him in his hand as he raised his hand from seeing the gun, I would imagine. Then to his right, immediately, right there, was Anna St. Juliana and Kylie and Riley. And he started shooting at them, and they fell on top of each other. And in the distance in the camera, you can see far end of the angle. You see what I found out to be was Madison Baldwin, and she crouched down, like I don't know if it was in, I don't know why she did it, but it was in the fetal position. And the shooter ran right up to her, and he put the gun right on her head. She just fell over. He rounded the corner into the longer part of the 200 hallway. Prior to running them towards Madison, he had just fired down the hallway, just, I don't know, just trying to hit anybody that was running out of there. He rounds the corner and starts shooting. You see a whole bunch of kids, and you see a whole bunch of teachers standing at doors, just grabbing kids as they ran by and just throwing them into a room. And then there's 2 girls. One you see, she runs up to a door and tries pulling it open, but the people inside had already put the little safety latch at the bottom of the door. She couldn't get it open. Meanwhile, the shooter's still walking towards, and another girl comes from the right side of the frame. and grabs the other one by the arm and just tears off down the hallway. Meanwhile, the shooter is shooting at them. The shooter keeps walking down the hallway past 200, I think it was a 400 T intersection, I think is what that was. And he levels the gun. And he fires 2 rounds, and at first I didn't know what he was shooting at. When you go to the section of video that time was when Tate Neer just comes in, and unknowing to him, he had no idea what was happening. The shooter leveled the gun, and just as Tate turned the corner, the shooter fired a round. And Tate fell instantly. The shooter took a couple steps and then leveled the gun again. And just to shoot Tate again, laying there, shot him. And you see Tate's body flinch. He then walks over Tate. At the top of the frame, you see his feet stop, the shooter's feet, and he turns towards a room that, looking at the frame, would be on the left, or would have been his left. And come to find later on, he had fired into a classroom where a teacher was. He continues on down the hallway, almost hunting for more victims or whatever. And he gets past a certain point, and there's no one else to shoot at because everybody had ran out of the school. Every door, every possibility, every door locked, whatever. And you see him turn around, and he stops at a classroom that, based on where the door is, you can't see deep into the room. It's like the room goes that way, but he can only see straight in. Well, as he's walking back this way, he can see the kids, I'm imagining, hiding in that corner, because he stops and fires off a few rounds through the glass. He then comes back, walking towards where Tate was lying. At this time, an assistant principal was standing there next to Tate, and the shooter just walks past her with the gun in his hand, and she said something to him. I'm not sure what she said, but you could tell, like, he turned his head, like, almost didn't even look at her, turned his head like in shame. I don't know. And then he keeps on walking down the hallway to the bathroom where the other victim, Justin, was. And he just, as he gets to the bathroom, he just stops and turns right and just goes right to the bathroom.
Did the shooter eventually exit the bathroom?
Yes, he did.
Before he did somebody else exit the bathroom?
Yes, another student.
Tell me what you saw there.
That student, he was, I don't know how else to say it, but I've never seen somebody actually run for their life. And that kid was running for his life.
Did the shooter eventually exit the bathroom himself?
Yes, he does.
Tell me about that.
Comes out of the bathroom and he looks around a little bit to see what's going on. Turns around and the bathroom, the doors sit back in like a cubby type area, so they're off the hallway, the main hallway you really can't see, but he turns back around. Eventually now, the 2 first responding deputies had gotten Jason Lure and Jens were coming down the hallway, and Lure was a little bit faster than Jens was, just because he was trying to cover more ground. You could see Tate laying on the ground, and Jens is walking a little bit slower. As he's walking up to him, the shooter he puts his hands up in the air and then goes down to his knees. As he's doing that, Jens realizes he sees something, and he yelled gun, from what he told me. And the shooter then lays down on his stomach, and Jason Lure come back, and that's when they take him to custody right there.
Based upon your video review, and you said you've had to watch hours of this?
Yes, sir.
Is it fair to say that the entire incident was about 9 minutes long?
Yes, sir. Yeah. He's taken into custody at 1300.
That's
1 o'clock, I'm sorry, it started at 12:51, he was taken into custody at 1 p.m.
Thank you, sir. I'm going to go through some of the evidence that you recovered in your forensic investigation. We talked about different information that you were able to draw upon from James Crumbley's phone, Jennifer Crumbley's phone, and Shooter's phone, as well as their social media accounts and emails.
Yes, that's correct.
So you've seen all of the bits of every exhibit in this case you've seen, is that right?
That's correct.
And you've seen the demonstrative portions of those exhibits in this PowerPoint portion.
Correct.
Okay. So you're aware, and everyone's aware, we have a citation with the evidence number on that slide, as well as a citation to where from these sources of electronic information is pulled from.
Correct. Yes.
Now, from what you reviewed of the exhibits, do they fairly and accurately depict the information that you extracted from the social media accounts and from the devices themselves?
Yes, it does. They do.
So we'll start in late winter or early spring of 2021.
Mr. Keys, can I just ask you, this source of electronic information, which exhibit is this specific?
This is not an exhibit, this is just a demonstrative aid for
Okay, all right.
Thank you. So we'll start with March 8th of 2021. Before we get into that, a little bit of background. You were able to obtain a Facebook Messenger chat between James and Jennifer Crumbley?
That's correct.
And tell me how you were able to obtain that.
What we talked about earlier, you can send search warrants off after authorization of a judge to obtain information on someone's social media accounts or phone numbers.
Okay. And did that happen in this case?
Yes, it did.
So I'm going to show you what's been admitted as, this is People's 44. Sir, what are we looking at here?
That's a Facebook chat from between James and Jennifer, and the green would be James Crumbley, and the blue would be Jennifer's.
Okay, so we won't do this with every slide, but just so we're on the same page here. It says from Facebook 691473442 JC Rumbley. What is that?
The numbers is the ID account that is signed by Facebook, and then the JC Rumbley is the screen name that was chosen by the user.
Okay. And then we have, in the bottom of the text bubble, we have the date. So this is March 8, 2021. The time, 3:09:50 p.m. And then it says UTC-5. What is that?
Just to tell you that it's been adjusted. So the normal information is captured in UTC time, -0. I mean, all time starts in the point in Greenwich. It used to be called Greenwich Mean Time, GMT. Well, now it's UTC, Universal, like whatever it means.
Coordinated time.
All time starts there. And depending on which way
Universal
you go,
coordinated
from that point
time
on the globe is whether it's plus hours or minus hours. And we're 5 hours away from where all time starts.
Okay. So let's go through this conversation. Blue from Jennifer, Ethan going to bowling. What's in green is James.
Correct.
What's the response there?
IDK, or I don't know.
Okay. Jennifer, what do you mean? I don't know. And what was James' response?
James says, I don't know, period. Exactly what I said, period. We'll know after he gets home.
Okay. And Jennifer's response, 3:12 p.m. Does he have his phone? Again, 3:12 p.m. Why isn't he home yet? 3:12 p.m. He should be home by now.
Correct.
Okay. And Jennifer at 3:12 p.m. and 56 seconds says freaking out. What was James' response?
He does not get home till 3:16.
So March 8, 2021, that was a weekday. From the combination of the digital evidence that you reviewed, location history, are you able to tell where James was when he was sending this message?
Yes,
Where's that?
he was at home.
And Jennifer's response, I told you to pick him up because he's upset, but I don't want him to do anything stupid, goddamn.
Correct.
That's March 8th at 3:13 p.m.
Correct.
Okay, and James's response?
dude, period, chill, period, he is fine, period, and I'm trying to fucking work.
I'm gonna move on to, again, March 8th, 3:13 PM. What does Jennifer say?
Jennifer replies with, does he have his phone? Question mark, question mark, question mark.
And James' response?
Yes, but he won't answer while he is walking. I will let you know the minute he walks in.
Okay. And Jennifer at 3:14 PM says what?
I'm serious freaking out. Then she says, is he home yet? And that was 3 minutes later.
That's March 8th, 2021. That was a Monday. It was 3:17 PM.
Yes, correct.
I'm going to move on to Exhibit 61. Again, James and Jennifer Facebook messages. Blue will always be Jennifer, is that right?
Correct, yes.
Okay. March 19th, 9:37 a.m. Tell us what Jennifer writes, please.
Jennifer writes, Ethan, awake?
Okay, James' response.
Yeah.
Jennifer?
Replies with, how is he?
And what does James say?
James then says, he woke up, looked like he had way, in all caps, too much to drink last night, complaining about a headache.
That's March 19th, 2021, 9:40 a.m. And what does Jennifer write?
She replies with, well, he was really worked up and out of control, so I can see why. She continues on with, all I know is he needs to eat, go to work hard, and not complain, and he can get his stuff back. And that was at 9:41 a.m.
Okay. And 10:15?
Jennifer says, you respond, I didn't get a call. I didn't get it.
Okay. And James' response?
He responds back with, one text says Jesus, another one says yes. He
Okay.
said, let me ask you a question. Why am I in your guys' room? LOL.
And that was at March 19th, 21, 10:17 a.m.?
Correct.
And Jennifer's response?
OMG. Oh my God.
What did James write?
James responds, I totally thought you were giving him a Xanax last night.
Jennifer's response?
He responded with, does he seem better? Then a second response, no melatonin.
Okay. And what did James say?
He responds back with, I know.
Jennifer's response at 10:18 a.m., please?
Jennifer said, but he hasn't had one before, should have only given him half.
And what did James say?
He is just doing his school, says his head hurts. He took Tylenol.
Okay. And Jennifer wrote, is he okay to work?
Correct, she did. And then James responds back with, yeah.
Okay. And what did Jennifer write at March 19th, 21, 11:38 a.m.?
Does he remember what he did?
And what did James say?
James responds back with, dude, I am working on a demo right now. I have not talked to him, and he is doing school.
Okay. Jennifer's response?
She responds back with, okay, then, geesh.
Now, you reviewed the entire phone seized from the shooter.
Correct.
Okay. Did one text message conversation stand out to you compared to the rest?
Yes.
Okay. And tell me, why did it stand out?
Just the volume of text messages back and forth, the amount that there was in just one chat.
Okay. Now, without telling us the person with whom the shooter was texting with that volume, can you tell us if you came to learn that the person who was texting was the same age?
Yes, he was.
And he went to school with him?
Correct.
All right. Tell us about the approximate number of text messages between the shooter and his friend.
There was over 20,000 text messages between the two from January to the middle end of October.
Okay. So that sounds like a lot to me, but I'm not an expert in computer forensics. Give us an idea of what that scope is.
20,000. I mean, that printed over 5,000 pages of text. I've examined phones that someone's entire chat conversation with everybody they had was less than 20,000. So it's just a large volume.
To put it in comparison between, let's say, James and Jennifer's Facebook conversation, what's the scope and the difference in size there?
I believe James and Jennifer was 10,000 text messages back and forth.
Okay.
For that same time frame.
So same time frame, we have double the amount of text message communication between the shooter and his friend is James and Jennifer.
Correct.
Okay.
You said January to October, is that both 2021?
Yes, ma'am, I'm sorry.
Thank you, Judge. Yes, 2021.
Yes.
Now, there were also, without going into detail, video shared as well?
Yes, there was.
Okay. And were some of the content of the conversation of highly personal nature?
Yes, it was.
Now, in comparison to any other conversation on the shooter's phone, what's the difference in size between that particular text thread with everybody else's on the shooter's phone?
He had over 20,000 text messages with his one friend. And in comparison, there was, between anybody else, there was a combined, I want to say, less than 1,000 between anybody else that he had chatted with.
So combined, less than 1,000.
Yes.
And then that one friend was over 20,000.
Correct.
Now, I'm going to show you just a very small portion of that, specifically April the 4th and April the 5th of 2021, which would be right about 2 weeks after the messages that we just saw between James and Jennifer Crumbley. This has been admitted as Exhibit 67. Names are redacted, obviously. Green is the shooter?
Correct.
Okay. Tell us what the shooter wrote April 4th, 2021, 11:56 at night.
He types, like, I hear people talking to me and see someone in the distance, and then he appears to try to correct the spelling of the word distance.
Okay. And April 4th, 2021, 11:56 and 50 seconds, what does he write?
I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up.
And 11:57 p.m., what did he write?
He continues on with, like, it's at the point that I'm asking to go to the doctor. And then he says, my mom laughed when I told her.
That was again 11:57 in the evening, April 4th, 21.
Correct.
Sorry, I muted myself.
April 5th, 2021. This is
I was just
after
noting
midnight. What did he
that
write?
according to the exhibit
He tells
title,
his friend, but I'm
this is
having
text
bad
messages
insomnia
between the
right
defendant's
now,
son
RN,
and the
paranoia.
defendant's son
And then
friend.
what did he write?
I need
So
help.
I'm still back
That's
with
at
how are we
12:11
bringing
a.m.
this in
Correct.
against the
And then at 12:12
defendant?
a.m., what did he write?
I was
Because he's not a
thinking
party to
I'd
these
call
messages.
911 too, so I could go to the hospital.
And there's no apparent indication that he was aware of these messages.
Continuing on April 5th.
And the message
12
says
a.m.,
things
what
like,
does he
well, I
write?
talked to my father about so-and-so.
Then my
Sounds
parents would be really
suspiciously
pissed.
like we're offering it for the truth of the matter asserted.
And finally, 12:38 a.m.
And also there's a
right?
confrontation clause
Says,
issue
I'm
on
going to
top
ask
of
my
the
parents to go
hearsay
to the
issue.
doctors tomorrow or Tuesday again. Then he continues with, but this time I'm going to tell them about the voices.
And finally, he writes at 12:39, 20 seconds, what?
Like I am mentally and physically dying.
See, he says this time I'm going to tell them. That sounds like it's being offered for the truth of the matter asserted. That, first of all,
You just
that was his
mentioned some
10. And second of all,
videos
that he
on the
did.
text message thread between the shooter and that friend. Is that right?
That's right.
So,
So I'm going to now direct you to
hearsay?
August the 19th of 2021.
And also, confrontation clause?
First of all, did some of those images that he
'Cause I
shared
can't confront Ethan?
depict firearms?
Yes, they did.
Who made the statements?
So this is exhibit 70 and 71. 70 is the text message itself. But what are we looking at here?
That's showing the video was sent to his friend.
Okay.
Does the
So it's same
the
kind of reference as
video
well.
depict
Yes, yes.
him and his
August 19th,
father?
2021, 9:31 p.m. And the video is 71.
Can't confront the friend to say he said it too either. Well, that wouldn't really get you very far because you're trying to figure out the truth of the statement and the friend wouldn't know. So you have to figure out the person who's really making the statement. I suppose you can confront the friend about whether or not the statement was made,
2021.
but we're still trying to figure out whether or not it reflects any reality.
What he was handling in his hand?
That was a handgun.
I don't know how they're admitted. I don't get it. How are we offering this video?
Exhibit 72
This is a
and
video of him
73
using the. How are we using
admitted.
this?
This is 8:20 a.m. and 12:30
Present
in the
sense
morning,
impression?
So
Bullshit.
carrying over past midnight from the last video.
Present
72 is this text bubble. So what are we seeing
present
here?
sense
He had
impression
some text to his
is
friend
not
that
the
he's been meeting
new
with,
what if any.
of
Okay?
Another video of a gun.
What if any doesn't
And
work?
this indicates that video
Present
was sent
sense
to his
impression
friend.
doesn't work.
Correct.
Please stop saying
We're
it.
73 now. Sir, do we see a round in that chamber?
Yes, there is.
Okay, when I say round in the chamber, what does that mean?
A bullet and a shell.
And that was August the 20th. Now, were you able to tell that the defendant or Jennifer Crumbley were actually inside the home when the video was taken?
Yes.
I'm going to go through. We talked earlier about how you're able to find certain.
It doesn't
location
matter
history.
because
Correct.
it's not a
Okay.
present
So,
present
is it
sense
fair to say that
impression.
we were able to do that for the specific date.
Only
That's correct,
matters
So this is exhibit
if
74.
the witness is on the stand
Bringing
or
silverware,
like the
bringing
person
along
you're
to
talking
James
about
Crumbley's
heard it,
location. Purple will be Jennifer Crumbley.
right? Oh, look, the car's
We're
going
looking
so
at here in exhibit
fast.
74.
So unless that
That's a
person's on the
GPS
stand
location
or
captured by Google.
the person
This
that
is
you're talking
the
about
Gmail
heard
account,
it,
JamesCrumbley8
it's not present
in the
sense.
upper right corner. And on
You know,
August
I mean, that
19th
doesn't make
at
any
9:21
sense.
PM.
Okay, so that's.
I mean, right now, somewhere in Houston, I'm pretty sure someone is witnessing a crime
So that
occur.
indicates at least that his device was at the
Okay,
location approximately the time of the first video.
I don't know how that relates to me though, because
This
I'm
is
not
exhibit
there.
75. This is purple again, so this would be Jennifer Crumbley.
Correct.
Tell us, please, what you see here.
Again, it's using the same Gmail account that they had. Her GPS location from Google was at 9:29 PM on August 19th.
Okay. And again, that's the first video.
Yeah, present sense is a statement that describes an event
This is
as it's
exhibit
happening.
76, specifically August.
But still,
20th,
it doesn't
2021,
matter unless you're talking,
12:32
unless you're
a.m.
questioning that
What do we see
person,
here?
Again,
or you're
another green
questioning a
circle
person who
indicating the
heard it.
location of James's device.
Like, did you
And
say
is
this?
approximately the same time
Or did you hear the
video
person
was
say
loaded on
this?
the
Correct.
Right? Because unless they have knowledge of it, someone else's impression is. I have nothing. I have no intelligent commentary to say. Like, you know,
Now, this
some
is
guy
exhibit
says,
72.
some guy right now in Houston
This
is
is
probably
part of
saying
that
something
same
like,
conversation
"Oh,
between
look
the
at that
shooter
drug
and his
deal
friend.
happen."
Yes.
Okay, and this was
And I'm like,
August 20th,
unless you
21
know
at
that I heard
12:32
it,
a.m.
what are we talking about?
Okay, so
If
that
I'm on
after the
trial,
video was sent.
That's correct.
All right, what is the shooter, right?
isn't it true
My
that,
dad
like
left the
Bob
house, so I
said, look at
thought,
that drug deal?
why
I
not?
guess,
LOL.
but how's that relate to me? The present sense impression doesn't get you to where you need to
During the course of
be.
your investigation, did you come to learn that this friend that the shooter was communicating with abruptly left the state of Michigan?
Yes.
Okay.
That's the reasoning the judge gave for it. Yeah, it
Did
doesn't
you
make any
learn
more
that
sense either.
Was done
It doesn't make any
without
more
notice of
sense the
shooter?
second time it's
Correct.
explained.
And what do you base that belief on?
James had reached out to
And
the
also,
father
not for
of,
nothing,
the shooter's
it's
friend,
not present sense
asking if
impression
everything
because
was
he's
okay,
not
and
commenting
then the
on
father of
something
the
he's
friend
observing.
told what was going on.
He's at best commenting about his own mental state, which isn't what present sense impression is,
79.
right? Because I'm commenting about my own psyche, where I do have motivation to lie, as opposed to something happening where I have no particular motivation to
This
lie.
is the father of the shooter's friend?
Yes.
Okay. And what's the date here?
This is on October 30th.
You know, so it's not really present sense impression.
9:52 p.m. What did he write?
He wrote, "Hey Mark, sorry for the late text.
And it doesn't
Hope
matter
you're
because they didn't know
well. Just
about it.
wanted to
And there's a
check in and make
confrontation
sure
clause
everything's
issue.
okay
So
with,
this doesn't make sense for at least three
the
reasons.
shooter's friend. Ethan's been trying to get a hold of him for a few days. Did not know if his phone was taken away. Maybe
James's
Let's
text
just check in.
message to
Ethan
Father
wanted to
VC's
be
friend.
with his friend
Okay,
for
well at least
Halloween
that's a
if he was okay.
message to the. That's a message from James, so you got that going for you.
For context, this is October 30th, 21, 11:01 p.m. This was in response to that text?
Correct.
Okay. And what did he say?
He says, "Hey James, thanks for checking in on him. Unfortunately, his friend is in a bad place with
The defendant is wearing earphones because he has difficulty
this
hearing.
week. We are taking him out to Wisconsin tomorrow to put him in residential treatment. He'll be gone for 60 to 90 days.
I mean, I think that's
By far the hardest
self-evident,
decision we've had to
but
make.
people keep
So he
asking.
probably
I don't
doesn't know how to
understand.
approach
Isn't it self-evident?
with Ethan or what
Why
to
else
say.
would he be wearing
I think he
headphones?
is probably embarrassed about the situation.
There's not a lot
and
of
there's a reason
explanations.
He is not answering.
It's either he has
Let
trouble
me talk
hearing,
to
or
friend.
he doesn't
I
speak
wasn't
English,
aware
and
that
there's
he
some sort of
wasn't
real-time
talking to anyone.
translation going on. I mean, you know,
And there's another text.
just saying, it's not a lot of
Yes.
possibilities here.
He responds, sorry for the delayed response.
Okay. And 10:30:21 at 11:03 p.m.
The father of the friend says, let me talk to him and see how he wants to approach it with Ethan.
Okay. And then what was James' response?
James responds with, Mark, please let me know if there's any way at all we can help. He is a great kid and always great over here and very welcome at all times. Please let me know if we can help.
So that's October 30th, 2021, 11:10.
It's possible he's listening to his favorite
Now, I want to
jams.
talk to moving to November of 2021.
Think about that. Anyone
Did you
who's like,
find
well,
any
possibly he's thinking he's
information
listening to his favorite
regarding
jams.
James
Yeah,
Crumbley's
think about that and try
employment
harder.
status?
Yes. I believe in you.
And tell.
I think you can figure that one out for yourself. Is it possible he's listening to his favorite jams?
That he had lost his job on the first of the month.
Okay. And did he subsequently find another job?
Yes, he did.
And do you recall when that was?
Oh my God. Mike
shortly
Tyson
thereafter,
is going to
started
box Jake
DoorDashing.
Paul in Dallas?
This is exhibits. Oh, I'm sorry, we're still on page exhibit 79. The response to
Mike Tyson is
James
going
Crumbley's
to
tax
box
was what?
Jake Paul?
Always,
Holy
the dad of the
shit.
friend says, thank you. He loves you guys. Hopefully we can get him better, and Ethan can spend some time over here too. He has to voluntarily go, so there's a chance he may not be admitted. If you don't mind for now, if Ethan asks, tell him he had to go out of town unexpectedly. If he gets admitted, then we can give him full disclosure. Is that all right?
Mike will be 58, Paul's 27. I have my money on Mike Tyson.
Here's exhibit 81. This is
I have my
the-
money on Mike Tyson.
you mentioned he was DoorDashing.
Mike Tyson might be 30 years older. I have my
And
money
you
on Mike.
executed- Well, you were part of the investigators who obtained information from DoorDash via search warrant.
Yes.
Okay. And
Mike is
with
going to
DoorDash,
destroy
if
him.
you are a driver for DoorDash, you install an application on your phone.
Correct.
And did James Crumbley have that on his phone?
Yes, he did.
Okay, so what is this in 81?
That's just from one of the things that is pulled out when we extract data, pull data off the phone. It's installed applications, and it just tells us that that app was installed, the Dasher app was installed on his phone on November 9th.
Okay, so that's when he would have put the application on the phone to start receiving orders to be a DoorDash driver.
Correct.
This is November 9th, 2021 at 8:35 p.m.
Correct.
All right. Now, did you come to learn that he also received messages when he logged
Mike
in
Tyson
and picking
will
up
own
orders?
him.
Yes.
Did you
First
find any
round.
evidence to suggest
Done.
that he worked anywhere else but DoorDash in the month of November of 2020?
No, I did not.
I'm going to put
Based upon his
bets
location
down.
history and other
Mike
information
Tyson
he
in the
obtained from
first
his phone,
round.
did you come to learn that when he did work beforehand, he was away from the house or in the home?
He was in the home.
Now, what about the shooter's digital footprint in the month of November 2021 after his friend left? When you reviewed the phone, the shooter's phone, for that month in particular, did you find any evidence of the shooter being in contact with anybody else, any other peer?
No, he did not communicate with hardly anybody at all.
Any evidence, either GPS pings, pictures, social media posts, text messages, anything to suggest that he met up with anybody outside of school?
No, if I remember correctly, there was, for the whole month of November, there was only 48 total text messages from the 1st to the 30th.
Okay. And what did those text messages include?
Combined 6 of them were to James and Jennifer. And then the rest were, I remember seeing, he was accessing some app, maybe doing homework or something, trying to find, it appeared like you would text it, maybe a math problem or something, it would send you the answer. I'm not entirely certain, but that's what it looked like.
Okay. But no evidence of plans to meet with a friend outside of school or?
No.
Or anything
Objection,
like
Your Honor,
that?
asked and answered.
I don't think I asked that one.
Keep going.
Okay. No, sir, when I talk about cache data, what does that term mean?
Cache data is data that's stored in a temporary file for your device, whether it's a phone or computer, to pull that information back up again quickly. Whether it's recently viewed or something you look at a lot, the computer can do it quicker because it knows it has to go to this one folder instead of re-downloading it.
Okay, so I understand it. Does that mean if it's, does that phone, every phone have a certain area of storage of cache data?
Yes, and every app, just depending on what the app is, it would have its own folder of cache data, yes.
Okay. So if there's something, for example, an image in cache data, what does that indicate to you as a forensic examiner?
It would imply that someone had to, it would have had to have been on their phone, they would have had to have seen it.
Okay. Now, what does it mean if two people have the same cache data on their phone for an image?
One either would have sent it to the other one or they randomly looked at the same picture.
When examining the phone of the shooter and examining the phone of James Crumbley, did you find any images in common in cache data?
Yes.
Now, I want to specifically take you to exhibits 82 and 83. It's in the extraction report and a screenshot. So first of all, 82 is the extraction report. This is the snippet of that, please.
She
me-
basically said sustained
tell me what
by
that
move
means.
on.
On
It's
82,
basically
Yes.
asked and answered. Move on.
That shows the name of that image.
that's
when
sustained by other
either
words.
You take a screenshot of something, it's going to name it real quickly, or you receive it, it'll name it real quickly so it can track it within your device. And then where it says path, that's the file path that often tells you what happened, how something got on a computer, on a phone, is by reading the file path.
So let's talk about file path for a second. Now, anytime you, as an expert in computer forensics and cell phone forensics, you're looking to find how a piece of data got on the phone. Is that right?
That's correct, yes.
Okay. And so how does a file path aid you in that?
It just tells, that right there, it tells us what they, like this one, for example, on the screen, it says Android messaging. I know this was done using the Android messaging app.
Okay, so this is from the shooter's phone, and the file path you said had Android messaging?
Correct. At the second line from the top, it says tar archive and then data / and then com Android messaging /.
Okay. Now, if something is found in cache data as opposed to just scrolling through the phone to find the image, what does that mean to you?
That they would have seen it on their phone before.
Okay. But why wouldn't you be able to find it just in messages?
Probably, if it was deleted.
Okay. So this is on the shooter's phone, and we have the forensic footprint of this image.
Correct.
And the image itself in Exhibit 83.
Correct.
Okay, so what is the exhibit itself in 83?
That tells you right there, that's a screenshot, because at the top of it, you can see the top part of your phone. Usually it has a time up there and the battery life and the antenna strength that you had, and you can see it at the top of that image.
Okay. So the screenshot here is 1239. And we have the extraction report in 82 to verify. It's Monday, the 8th of November, 2021, 12:39 p.m. So that matches the screenshot?
Correct, it does.
And because Exhibit 82 has the actual time and date stamp with the UTC -5 that matches the screenshot, what does that mean to you?
That image, that's the image that was sent with that.
Okay. And this is on the shooter's phone.
Correct.
All right, so this is, this also has the file path here at 12:40 p.m. Tell me what we're looking at here.
This one, so this file path is a little different. Again, starting where you see the word path on the screen there, and then going over, second line from under tar archive, it's the tct.cs.rcs. And the RCS tells me that is rich content, and that's Android's way of being able to either share large files, to know, a lot of people have an Apple phone, you can tell when someone's texting you back. That RCS feature allows Android phones to do the same thing.
Okay. So as the forensic examiner, you can tell us that that screenshot was sent by the defendant's phone by the shooter's phone based upon the file path?
Absolutely, yes.
Okay. Now here's exhibits 85 and 86. This is from James Crumbley's phone. What are we looking at here?
On the right side is, the left side, I apologize, is the extraction information that was given, the name that was given in the file path, and then the screenshot again on the right side.
Okay, exhibit 85, the extraction report here. It has the date and time. It's November the 8th, 2021, but this is 12:40 p.m., so that's later in time than what was found on the shooter's phone.
UTC is Universal
Correct.
Coordinated
Is it
Time.
the same screenshot?
Correct, it is.
Now, did you find either screenshot
Tony,
of the 9
Universal
millimeter
Coordinated
of the
Time.
price, $299.99. Used Smith & Wesson SD9VE in very good condition. Comes with 2 16-round magazines and cleaning kit with an image of a firearm. Is that right?
Correct.
Okay. Did you find that screenshot in either messaging from James Crumbley or the shooter?
From James Crumbley?
Yes.
No.
Okay. But did you find it anywhere else on the phone other than the cache sheet?
No, I did not.
Okay.
Why is it UTC and not UCT?
Have you seen reference to
Because
SD9VE,
it was
9
a
millimeter
joint,
Yes.
in its initial
In the
form,
shooter's
it was a joint decision
because it's
between
on
the
cache data
English-speaking
nowhere else,
world and the
what does that
French-speaking
I
world.
would have had it one time.
And so they picked an acronym that didn't work in either language to make them both unhappy.
So I can look at it if they want to open it up.
That's
so
why.
The fact that it's in the cache data tells me that they had opened it up
Okay.
to see it.
Because they couldn't agree on which abbreviation to use. So they picked one that made them both unhappy.
Recover deleted content.
There you go.
Potentially.
Tell me what.
Each Android phones are different. So depending on the manufacturer of the phone, whether you have either a high-end phone or a simple throwaway phone that you buy at Walmart, the Android operating system can be changed to suit the
Coordinated universal
manufacturer or
time?
the reseller's specifications. So if you want to sell a cheaper-end phone that doesn't have
Wiki?
all the
Damn it.
functionalities of a higher-end phone, usually doesn't have the features to be able to store longer content or retrieve deleted content.
Okay. So it's nothing to do with your forensic tools per se, it's just on the manufacturer?
Correct.
Damn it.
Is it more likely to recover deleted messages after both users delete the message?
No, it's no. Is it more difficult?
Yeah.
Correct. Yes.
Okay. So the fact that this was found in cache data and nowhere else, that's significant to you?
Yes.
Why?
That it was on the phone at one time and now it's not there.
Well, at least I was right
Developers
about
have
why the acronym
Yes, they
came
did.
to be. I was just wrong about what it meant in English. So, well, when you actually somebody, you better be right. So I feel foolish. I want to go slink away into my corner.
Before the shooting. We'll start with November the 26th, 2021. Now, sir, given the tools available at your disposal and the information you're able to pull from, I'm going to ask you to build as best you can a digital footprint of the Crumbleys from the 26th of the 3rd.
Okay.
Now, are you familiar with the firearm purchase of the 6-hour 9mm on November the 26th, 2021?
Yes.
Okay. But based upon data locations and other information that you were able to retrieve in your investigation, are you able to tell us approximately when that purchase occurred?
Yes.
When?
It was between 1 and 2 p.m.
Well, I'm going to show you Exhibit 87 here. This is data location from 12:08 p.m. on 11/26/21. So what are we looking at right here?
I apologize. It was between 12 and 1 p.m. They were at the gun range there, or the gun store there.
Okay. So this location here verifies that James Crumbley's device was at that firearm store where the 6-hour purchase that day?
Correct. Yes.
And this is Exhibit 88. This is 12:57 p.m. And we can see East Street as far as where we're oriented towards the map. What are we looking at here?
That shows James Crumbley's location relative to his house at 112 East Street.
Okay. So what can you surmise from these data points?
That this one in particular, the larger the circle is, more, I don't want to say less accurate, the larger the range where the device should be. This one in particular is 62 meters from that point. So he could be anywhere within 62 meters of that point there near his house.
Okay. So because we have a more narrow point in Exhibit 87, we can be reasonably assured that the device was at the firearm store from 12:08, and then at 12:57, he was getting within 62 meters of his house?
Correct.
Okay. Now, to the extent possible, I'd like us to go through what the Crumbley family did after the purchase of that firearm on November the 26th. Tell us what you saw on their phones, what they did after the gun was purchased.
They went Christmas tree shopping. There are pictures of it.
Sir, when someone takes a picture of something, is there a way to tell where and when that picture was taken?
Usually, yes.
Tell me what.
So a picture that's taken with your phone or even a camera that you might have, a Canon camera, captures what's called metadata. You usually tell your phone to do it. And metadata is data within data. So the main information here that you see on the screen is of a map. Well, embedded in that could be how that map was made by the camera that took the picture, maybe the computer that took the picture, how even the screenshot was made. That's information that you don't see. That's the metadata.
So we're looking at exhibits 89 and 90 here. So 89 is the metadata, 90 is the photograph itself. Tell us what we're looking at here.
That's was taken from the shooter's phone, and he's holding a handgun that was purchased on the 26th.
And the handgun on the grip there says 6-hour.
Correct, it is.
Okay. And so when and where was this picture taken?
This was taken at the Crumbley home on November 26th
And what time?
at 1:03 p.m.
Okay, so we saw from the location history that James Crumbley was almost at his house at 12:57 p.m. And this photograph was taken 6 minutes later?
Correct.
And did the shooter post anything on Instagram with regards to this firearm?
He posted pictures of him holding the gun, and then telling people, ask questions, they'll answer.
So here's Exhibit 95. What do we see here?
That's the Instagram post where the shooter wrote, "Just got my new beauty today, heart eye emojis, 6 hour, 9mm. Ask questions, I will answer."
And when was this post made?
In the bottom left corner, you can see it was November 26th, 2021, and it says 1806, which is 606 UTC, and that's what I was talking about. We're -5 or 4 hours. So in November, we're -5 hours, so staying at 306.
All right, here is also Exhibit 95. What do we see here?
106. I apologize. It was 106 I was taken.
106.
Minus
I was
five.
gonna correct the math, but-
Yes, I apologize. Another picture of him holding it in his hand, and that was taken shortly after at 106 p.m.
Okay, so same caption, the post, different photograph.
Correct.
All right, and here is, again, same time, same caption.
Yes, just looking down the sights of the gun.
Okay. We see 3 dots at the top of the firearm. What is that?
Those are the sights of the gun. The two on the outside, and the front post. If you don't know, you line those up. It's called your sight picture. You get those 3 dots in a line. If you have equal light on either side, it's where your round's going to go. And he's just practicing lining up the sights.
And that's lined up in a way where he would fire the way you would want it to. That'd be right?
You put a round right below it. Yeah.
And same caption, just got my new beauty today, 6 hour.
Okay, I get it for 5 seconds to get some water. What did I miss? You know, you hope that they're going to carry for you, right? You get up, get some water, and you get back, and it's all gone to hell. You were supposed to stand in for me, stream, so that I could actually, do things like get up and get some water. Jerk. Well then. What do you guys want to talk about while we're waiting for the court to come back? Ask me anything. Ask me anything. Legal, we can talk about Trump legal cases. We can talk about Supreme Court. We can talk about Houston. We can talk about the channel. We can talk about, what do you guys want to talk about? How was the move? Annoying. It was interesting because I don't realize how much stuff I have. And I threw away a lot of stuff and I still had too much stuff. And it's like, I didn't think I had that much stuff because I threw away half the things basically I owned the last time I moved. And I didn't think I had things to throw away again, but I threw away quite a bit or took it to Goodwill, as the case may be. And when the moving company arrived at my new place and everything was inside the unit, still in those boxes, I was like, who ordered all this stuff? You know, who ordered all this stuff? I don't need all this stuff. This is too much stuff. And then you put it away into its respective cubbies and everything, and you're like, I don't have that much stuff. So apparently object permanence is something I have trouble with. I mean, it's literally something a 3-year-old learns, is object permanence. But apparently I'm like, yeah, I don't have that much stuff because I can't see it anymore. So that's interesting. Is there a reason I moved? Yes. Nate, the lawyer, who is my good friend and has been my close compatriot in LawTube for quite a while, moved to Houston. Oh, they're back.
November
Yay.
27, 21, correct?
Correct.
Now, this is Exhibit 101. This is Jennifer Crumbley's Instagram post. What do we see here?
She posted the target that she had shot and posted with it, Mom and Sunday testing out his new Xmas present. My first time shooting a 9mm, I hit the bullseye.
Did you go buy a bump stock before they're banned? Strictly speaking, they're banned as we speak. And no, because if the law is upheld, then you'd be in immediate violation. You don't want to be filmed.
Another photograph here. Same pose?
Yes.
Same time?
Yes, it is.
Okay. And finally, what do we see here?
That's the Sig Sauer handgun right there with the magazines and the pamphlet.
So because all three indicate Mom and Sunday testing out his new Xmas present, my first time shooting a 9mm, I hit the bullseye. Does it indicate those three pictures were posted together?
Yes, they were.
Yeah, I know you can't see me. I'm going to get a little bit more food. Be right back.
Well, here's Exhibit 102 here. This is it. This is 2:03 p.m. What do we see here?
This is Jennifer at her house at 9:27 at 2:03 p.m.
Okay, and so that's practically the same time those photographs, those posters were, those images were posted?
Correct.
So the fact that they were posted at her device or her social media accounts through her device, and we have a device location here, what does that mean?
That she was at her house when she made that post.
And were you able to tell if James Crumbley saw these images?
Yes.
Here's Exhibit 103. What are we looking at here?
This is data information from the cell phone extraction. And again, back to the file path that I talked about, you can see the third line down in the second column. You see tom.facebook.katana/cache indicating that it's in the cache folder.
Okay. So like the screenshot of Smith & Wesson 9mm sent by his son to him, these images were also found in the cache folder?
Correct.
Now, we will obtain data locations from James Crumbley's Gmail account for November the 27th, 2021.
Yes.
Okay, that helped you identify where he was that day?
Yes.
Okay. So we'll go through exhibits 104 through 107. Here's 104. What do we see here?
It shows James' location. It's near the gas station of the Meyer at Ray Road in 24.
Okay, and we already talked about at this point in time he was working for DoorDash.
Correct.
And we already identified the fact that when there was an order ready, he would receive a text message from the DoorDash app.
Correct.
Okay, so were you able to tell what he was doing that day?
Yes.
What was he doing?
He was door dashing.
Okay. So 9:37 a.m. indicates one position where he's at, and looks like he's back home at 5:32 p.m.
Correct.
And here's exhibit 106. It's about 6:03 p.m. He's out of the house then?
Correct.
Okay. And 6:33 back home.
Correct.
Now, what about Jennifer's locations from that day? Were you able to obtain any idea where she was that day?
Yes.
This is exhibit 108. What do we see here?
It's the purple dots indicating Jennifer's locations.
Okay. So we have 2:29 p.m. to 3:32 p.m. and locations outside of the home that would indicate what to you?
She was at home. She was out and about.
Okay, just to make sure I'm clear, on the 27th, we see James Crumbley leaving home 9:37 a.m., returning at 5:32 p.m., leaving again at 6:03 p.m., home again at 6:33 p.m.
Correct.
And the same day, Jennifer's gone from about 2:30 p.m. to 3:30 p.m.
Correct.
Now, Sunday, November the 28th. This is exhibit 109. Tell us what we're looking at here.
That is GPS location for Jennifer on November 28th at 12 p.m.
So she's obviously away from her home. Do you know what that is location?
Yeah, that's where the horse farm is.
Okay. Now, you say horse farm, you went through all of the digital evidence in the case,
Correct.
okay, including the Facebook messages between James and Jennifer,
Correct.
the messages from James to anyone else or Jennifer to anybody else.
Correct.
Okay. Are you aware of James and Jennifer spending time at the horse farm?
Yes, sir.
Okay, and tell me how you're aware of it.
Your Honor, I'm going to object to relevance.
We addressed this, Judge. You addressed it in your earlier opinion as well.
I think we did. I'm not allowed. I think your objection is to wait. That is.
Thank you, Judge. How are you able to know that, Judge?
But how many times they talked about whether I'm going to the barn to do this or work on this horse or take care of that horse? Yes.
Okay. Give us an idea of how many times we talked about it.
They talked, it was mentioned within their chats 86 times of going to the barn.
I'm sorry. The period of time.
That was from January to November.
From that conversation, we're able to tell if they would go together or if they had a plan to.
Both. They would go take care of, one would go take care of a horse or they'd meet up there together.
Here is exhibit 110. This is Sunday the 28th at 2:07 p.m. This is at the Crumbley family home?
Correct.
Okay. So these last two pieces of the exhibit indicate that Jennifer Crumbley was at the horse barn from approximately noon to whenever she left, arriving home at 2:07.
Correct.
And that's the Sunday after that firearm, the 9mm, is purchased.
Correct.
Now let's talk about James' data location points. Here's exhibit 111. What do we have here?
It shows his location at the Meyer gas station again.
Okay, and tell us what he was doing that day from your review of the digital evidence.
That day he was door dashing again.
So this is a data point at 8:56 a.m. Exhibit 112, it's 12:45 p.m. Here's he's back at the house.
Correct.
Did he leave again?
Yes, he does.
Okay, here's 113, exhibit 113 at 12:52 p.m. What do we see here?
It shows him going away from the house.
Okay, and exhibit 114, what do we have here?
At 5:13 p.m., he's back at the house.
Okay. So all this tells you that James left at 8:56 a.m., returned at 12:45 p.m. He left again 7 minutes later and returned 5:33 p.m.
That's correct.
Okay. Now I want to move on to Monday, the next day, Monday, November the 29th. I'm going to talk about a Facebook conversation between James and Jennifer Crumbley from that day. So this is exhibit 115. Jennifer Crumbley at 8:23 a.m. on Monday, November the 29th. Are you at the barn? And then follow up just a question mark at 9:02 a.m. Is that right?
Correct.
Okay. So again, blue is Jennifer, green would be James.
Yes, sir.
Okay. When you mentioned like the 86 times you talked about the barn, is this what you were referring to?
Yes, it was.
Or is this a portion of what you were referring to?
Correct.
James's response was what at 9:05 a.m.?
Working on Billy.
Okay. And did you come? Who's Bill? Did you?
I couldn't find it was one of the horses.
All right. This is also part of 115. What did James send to Jennifer?
He sent a photo. It's the horse's legs.
Okay. And Jennifer's response?
Do the fronts too.
So that's 9:21 a.m. on Monday, November the 29th. What did Jennifer write to James after that?
She asked him, did you call the vet yet? And then tells him, make sure you get back in between his heel balls.
And James's response was, I did, at 9:34, then fronts 2 right after.
Correct.
And James wrote what at 9:35?
He says, what exactly should I tell the vet? Type out for me, leaving the barn now.
Okay. And Jennifer's response was what?
Billy looks to have scratches / mud fever. He's starting to stock up on all fours and concerned about infection. He's not lame, sensitive to the touch, and they go down when he moves. Is there an antibiotic I can get him on? We just put Desitin, an antibacterial, on his legs today.
Okay. And then she wrote what?
She asked, was he stocked up this morning?
Okay. So that was 9:41 a.m.
Correct.
And James's response at 9:43?
He responds back with, he was stocked up more in the back than in the front. In fact, the front didn't really look stocked up at all, so I launched them for a few minutes before. I put the stuff on it, and it took the swelling down a little bit, but I got that cream all over, in between his heel bulbs and stuff like that. I'll call the vet here in a minute.
Okay. And then you wrote, talk to tax FYI, so I have no idea what I really just said.
Yes.
Jennifer, it made sense, LOL, at 9:58, and then James's response at 9:59.
James responds with, I just talked to the vet, Carrie. Said she's going to talk to the vet once one of them get back in, and she will give me a call back. I explained everything exactly how you wrote it down. Good thing you wrote it down like that, LOL, for me.
Okay. And her response was, okay, good, LOL.
Correct.
Okay, so this conversation regarding the barn and the vet started at 8:23 a.m. and it went until 10:15 a.m.
Correct.
Okay. Did you come to learn if a message was left for Jennifer Crumbley while this conversation was going on between James and Jennifer?
Yes, there was.
This is Exhibit 116. William, can we have the volume up?
Hi, Ms. Crumbley. My name is Pam Dye. I'm calling from Oxford High School, and I'm here with Mr. Hopkins, who's Ethan's counselor. I was just calling to let you know that we just spoke with Ethan, had a really nice conversation. One of the teachers had sent an email to the office that she was concerned with Ethan when she was walking around the room, checking his silence, but he was on his phone looking at bullets and that sort of thing. So she just wanted us to have a conversation. We did. He said he had been to the shooting range with you this weekend, and we were like, yeah, guns are a hobby for a lot of people, and shooting ranges, and that's perfectly normal. And that we just wanted to make sure that I had a conversation with him about the things he searches at school, and things versus searching at home, like Mr. Hopkins gave a good example of like if the teacher makes beer at home, perfectly normal and healthy, but can't be using searches for making beer at school. So we had a conversation. He was great. He was like, yep, I get it. So I just wanted to let you know that we did have that conversation with him, and I don't know, about 5 minutes, and he went back to class. All right, if you have any questions, you can give me a call. Otherwise, I hope you have a great holiday. Great. Bye-bye.
I think I'm going to have to make a call to my health insurance company here, so I might have to step off again, but I'll keep the stream going if I do, just to let you know.
Yes, you did.
Is that depicted here in People's Exhibit 117?
Yes.
Could you find from the messages between James and Jennifer who picked their son up from school that day?
Ethan did. I apologize. James did.
Here's Exhibit 120. This is Jennifer Crumbley, you still working, 2:44 p.m. James says no, waiting for their son, 2:47. Okay. And 119, this is later on. What does Jennifer write to James?
She asked you, did Ethan tell you what happened today?
Okay. And that's the same afternoon that the voicemail was left?
Correct.
Okay. And James's response?
Was yeah.
Now we're going to move on to November the 30th. We'll go step by step from what you were able to discern from all of the evidence that you had to review this. So in the morning, November 30th, were you able to tell what time the shooter was dropped off at school?
after 7:30 p.m. or a.m.
So you able to pull surveillance video for this? This is exhibit 122, 7:46 a.m. on the 30th?
Correct.
Tell us when you recognize him, please.
He got out of the car a second ago. He's the last one walking up.
Right there?
Yes.
He was dropped off by his father?
Correct.
Exhibit 123, tell us where James Crumbley went after that.
At 8:04 a.m. he was at home.
Okay. And then exhibit 124, where was he?
At the horse farm again.
Okay, so 9:04 a.m. So 7:46 a.m. he dropped off his son. He was home at 8:04 a.m. He's at the horse barn by 9:04.
Correct.
Do we know what time that Jennifer Crumbley got to work?
About the same time, 9:04.
So this is what we're looking at here.
That's Jennifer walking into her replacement appointment.
This is exhibit 125.
Yes.
Okay. And this is November 30, 2021 at 9:04 a.m.
Correct.
Now, do you know if you received a phone call shortly after arriving?
Yes, she did.
So exhibit 126, what do we have here?
That's from the call log obtained from her phone from the school.
Okay, so we have a missed call at 9:24 a.m. on November the 30th.
Correct.
And then we have a return call at what time?
9:27 a.m.
And how long is that phone call?
That's 5 minutes, almost 6 minutes.
So is that 5:43? It's 5 minutes and 43 seconds?
Yes, it is.
Now, next in the timeline, 9:31 a.m. What are we looking at here?
That's the screenshot or a picture of a math sheet homework that the shooter had.
Okay. So this was sent to whom?
To Jennifer.
To Jennifer Crumbley?
Yes.
Okay. Exhibit 128, what's this?
That's the full-size image of it, of the math sheet.
So did you come to learn there were actually two different math worksheets?
Yes.
Okay. And this is we're referring to the altered one?
Correct, it is.
So this was sent to Jennifer Crumbley at 9:31?
Correct.
Right? It's exhibit 128. Exhibit 129 is what?
That appears to be an email of the math worksheet.
Here's exhibit 30. This is what contained in the email?
Yes, that's the original.
So this was emailed to Jennifer Crumbley at 9:32 a.m. Is that right?
Correct.
And the scratched out version was texted to her at 9:31 a.m.
Correct.
Okay. Now this is exhibit 131. This is at 9:33 a.m. So this is 1 minute after that original drawing was sent to Jennifer Crumbley. What are we looking at?
Jennifer telling James, call now, emergency.
Okay.
And then she says again, emergency, 2 minutes later.
And then at 9:38 a.m., what does she send?
She sends the two pictures of the math worksheet.
Okay. So the one that's scratched out in the original, the correct that were sent to Jennifer?
Yes.
And James's response at 9:44 a.m.
James responds with, my God, WTF.
And then what?
Vet not here yet. It's McElmurray for Kira's horse, still waiting on vet.
Okay. So we saw earlier that his location indicated he was at the barn by at least 9:04 a.m.
Correct.
Okay. And this was at 9:45 a.m.
Correct.
And what did Jennifer write?
Responds back with, he said he was distraught about last night.
James?
James says, we talked about it this morning. Then he asked, you talked to him, question mark.
And what did Jennifer respond?
Responds with, can you call?
That's 9:57 a.m.
Correct.
Okay. And what does Jennifer write at 10:04 a.m.?
She says, heading to a school, I'm very concerned.
And that's at 10:04 a.m. on November the 30th, 2021.
Correct.
Did you learn that they both arrived at Oxford High School?
Yes, they did.
And did you learn approximately the time they arrived?
Yes,
What time is that?
about 10:30, 10:36.
This is exhibit 132, 9:36 a.m. You see James' location history that's still at the barn?
Correct.
Okay. And 134, this is the same surveillance footage that we saw Jennifer Crumbley arriving at work at 9:04 a.m. This is at 10:06 a.m.?
Correct.
Okay. And this is consistent with what we just saw in the Facebook messages when she wrote heading to school?
Correct.
Okay. This is exhibit 126. What do we see here?
It's a call to the school, to the counselor from Jennifer.
Okay, so she left at 10:04, then at 10:07, she called the same counselor who called her.
Correct.
And exhibit 131 headed to a school at 10:12. So that would be the timeline for that period of the day.
Correct.
So do we have an idea of, you said about after 10:30 a.m. that meeting occurred?
Correct.
Okay, and so is this what you base that opinion on?
Correct, yes.
All right, so what do we see here at exhibit 135?
What you see at the top of it is the horse barn, and then he takes a path down Gardner Road and then heads to the high school.
Okay. So if I'm correct, what we just saw, the Jennifer arrived at work. Well, first of all, the shooter was dropped off at school at 7:46 a.m. by his father.
Correct.
He went to the horse barn at 9:04.
Correct.
Jennifer arrived at her place of employment about the same time, 9:04.
Yes, sir.
Okay. And she received a phone call at 9:24.
Correct.
Then we saw the messages sent from her counselor, the phone call from her counselor, and the messages thereafter with those two drawings.
Yes, sir.
And then the Facebook messages, it's directly after to James with those two drawings.
Correct.
Okay. And this shows when he left the horse barn and about the time he arrived at Oxford High School.
Correct.
Now, did he stop by his house before he went to the meeting?
No.
Jennifer stopped by the house before she went to the meeting.
No, sir.
Did they go in one car or separate cars?
They were in separate cars.
Okay. Now, we had discussed this particular aspect of the case in a separate hearing some time ago, and there was an original belief that they arrived in one car.
Correct.
Okay, you came to learn that they arrived in two different cars.
That's
When
correct.
are leaving?
Again, it's just foundation. Tell me that.
When I originally was watching the video, the system that the school has, it's not continually recording. It only records when there's enough movement in the frame. So if they're too far of a distance away, it's not going to record, even though there might be somebody walking across the parking lot. The sensors don't pick it up. And it didn't, once I saw the second car, what I thought was the first car, pull into a parking spot, the next thing I saw was just two people standing in front of it. So I assumed that they had come out of that car together.
So, keeping with our timeline here, 10:29 a.m. We have a call log of what do we see here?
James calling Jennifer.
And how long was that phone call?
7 minutes and 16 seconds.
And based upon what you found on the video and the messages and data locations before they arrived at school?
Yes.
Now, you were able to pull the surveillance footage of both vehicles arriving and their movements while inside the Oxford High School, at least that were contained on surveillance video, is that right?
Correct.
Okay, so this is exhibit 137. I'm going to play this. And just so we know, at the bottom of the screen here, we have a description of the camera, what it's looking at with the time.
Correct.
So this is 10:36 a.m. on November the 30th, 2021.
Correct.
And this, what are we looking at right here?
That's the parking lot of a school on the north side of the school.
Sir, whatever you're able to give us some context of what we're looking at.
I come to find out that that's Jennifer pulling up right there in that car.
Okay.
And then there's James and Jennifer walking up to the school.
Right here?
Yes.
So this is James and Jennifer Crumbley in the Oxford High School that day?
Yes,
Okay.
that's in the office there, and they're being directed around to counseling.
At the bottom of the screen there, it's 10:39 a.m.
Correct.
So it just might actually be a good time for a short break before we plan to take one.
Do you want to read this thing?
That's fine, Your Honor.
All right, so I'm going to let you sit down and get the special testimony. All right? We just about a 10-minute break. Okay.
All right, for the jury.
Thank you very much to MS Jax M for upgrading their membership to the $5.99 tier. We do appreciate everyone who helps to support the channel at higher levels. It is very kind of you. And we do appreciate Unlicensed Streamer for subscribing, and also just a kind reminder, of course, that you can, of course, subscribe to us on Twitch for free. I was trying to figure out how to get the alert to pop up on a periodic basis, but I couldn't quite figure it out. I have a GIF that will give the information, but I need the GIF to like display and then not display for like 5 minutes or something. I don't know. I need to figure something out. But I'll figure it out later. And I'm still trying to and I'm still fighting with my health insurance company. I have to change my health insurance company because I moved. It turns out, apparently, the health insurance company I have only has doctors in Austin. That's a very specific health insurance company. I mean, I just have to say. So yeah, I have to go back into the marketplace and get different insurance due to a qualifying life event, namely moving. And I don't have any doctors within like 100 miles of me. Lol. So I'll do that at another time. Yeah. Like, can I see a doctor in Houston? No, we don't have any doctors in Houston. All of our doctors are in Austin. For your entire insurance company, yes. Only Austin. Okay. That's a very specific health insurance company, man. I'm just saying. Thank you very much for saying you like the new studio setup. I do too. I like it too. I really like the way it's turning out, and yeah. The marketplace is tough to deal with. Well, right now I'm having a tough time trying to figure out how I apply for a qualifying life event, because every time I apply it wants me to log in, and then I log in and then I try clicking the link again. It wants me to log in again. So right now I'm just trying to figure out how to apply for a qualifying life event. Man. Healthcare is crazy? Yeah. Why he have headphones on? Think about it. Okay, here's what I want you to do. I want you to use your brain parts. Why do you think he has headphones on? Think. I believe you can answer your own question. I believe in you. Yeah, I know I qualified because I moved, and I just have to figure out how to actually apply for that. And it just kept cycling me around and around, so I was fighting with it. Call it the marketplace number? Okay, I'm gonna have to do that. Because they look cool. Yeah, do you think that's the Occam's razor solution? Yeah, what conclusion draws the fewest assumptions? Right. What assumption draws the which conclusion draws the fewest assumptions? Of all the myriad of reasons he could have headphones on, which one strikes you as having the least assumptions to it? I don't feel like this is hard. I really don't. The background looks better being closer to me, and I also like the blue backsplash. It's nice. Here it's pretty common with headphones for translators. See, that's not actually a half bad conclusion. See, but at least you're thinking, right? So yeah, maybe it's a translator. Although they wouldn't use headphones for that purpose in court. They just have someone like reciting it. They wouldn't do it. They'd just have someone saying it out loud. You know, so, but they wouldn't use headphones. But at least it's a good guess. But, you know, yeah. I mean, you've seen his text messages also, right? We've been talking about his text messages. He seems to be able to text in fluent English, so probably not that he can't understand English, but you know. Yeah, he's listening to a podcast or music. Do you really think the judge would let him? Do you really think that's an option, Your Honor? I'd like to be here. Also, I know I've been arrested and everything, but you know, I know I have to be here and everything. But it would be cool with you if I put some jams on my earphones. Do you really think the judge would allow for that? Again, what makes the fewest assumptions? Right? It's probably that he's hard of hearing. It just seems to me to make the fewest assumptions. It's like, you know, maybe that's just me. Maybe that's just me. A lot of bilingual folks ask for interpreter just to be difficult. I mean, there's differences in language. You know, being truly fluent in multiple languages can be tricky. Even if a person, and also like what language you're talking in. So even like world leaders who are known for being able to speak in multiple languages, you know, there's a reason they use a translator sometimes, because they feel like they can be a little bit more accurate talking in their own language, or they think easier, or whatever. You know, I've heard, for example, Putin can speak in English, but he doesn't. But people who have known him say that he's not as comfortable speaking in English. He doesn't understand it quite to the same level of degree as Russian, which, you know, fair enough. So he wants to speak Russian. Is that why you can't understand Biden? He's speaking another language? It could be. That could be the reason. We did have one U.S. president who wasn't a native English speaker, although I can't tell you which one off the top of my tongue. Van Buren? Was it Van Buren? Who wasn't a first language English speaker? We did have one, but that was a long time ago. Van Buren Dutch, did I get it right? Did I actually get the president right? If I remember that factoid out of the back of my head, I'm really impressed that I managed to get the right president. Wow, I feel really smart now. Wow. Wow, that I'm really happy that factoid somehow popped out of my brain. I feel intelligent now. Plus one to my ego. That was nice for my ego. I'll take it. Still, so yeah, we've had a lot of interesting one-offs as president, right? So Grover Cleveland, so far the only president to serve two non-consecutive terms. But my all-time favorite has to be Taft, just because after being president, he went on to be Chief Justice for like 20 years. Can you imagine that happening today? Can you imagine the president of the United States leaving office after 2 terms and him actually getting past the Senate to be the new Chief Justice of the United States? Can you imagine such a thing? That may never happen again. Well, it happened once. Fat ass had a rich career. We've had a couple Supreme Court candidates, Supreme Court people run for president. One of them came pretty close. One of them was the major nominee once. And there's no way I'm going to remember his name. That was a long time ago. But yeah, we did have a Supreme Court justice who ran for president. Didn't win, but he was the party's nominee, so there's nice. There's some factoids from history. Metric is objectively superior. I tend to agree. The only way that metric is arguably non-superior is temperature. But that's just something you get used to. Because Fahrenheit degrees are not as wide as Celsius degrees. They're a little bit more precise, which is nice. But, yeah. John Quincy Adams was president, then became congressman. That's right. And one of them also, after leaving presidency, became a senator. I don't remember which, but yeah, one president left and became a congressman, one left and became a senator, one left and became Supreme Court Chief Justice, one left and ran for president, came second. He actually came pretty close, as memory serves. I think it was pretty close. I think it came down to like only a couple thousand votes in California. But it's been a while since I read that one. Can the fact that Jennifer was always convicted be used as a prosecution against James? No, it's completely irrelevant. I mean, it's pretty irrelevant, right? There can be more than one substantial cause. That someone else is a substantial cause doesn't really say anything about you. And we talked about this, for example, for the death of Chauvin. Or, no, the death of Floyd by Chauvin, rather. Right? The knee on the neck. We've talked about this. Like, did the fentanyl kill him? Yeah, probably. But that doesn't mean that Chauvin didn't also kill him. Because he's a substantial contributing factor. He beyond a reasonable doubt, at least in my humble opinion, exasperated his death. And so it's like, well, you're there. So that'll do it. Can a president that served terms be vice president? I suppose, well, I'd have to go look up the precise line. Well, let's go look it up together. I think the answer is technically yes, but in a very, very technical way. Let me go look up the language of the Constitution. We have had vice presidents that served under multiple different presidents. That's happened before. So we had a vice president who served under more than one president. I guess he liked the job so much he did it more than once. Johnson was president then senator? Yeah. The 22nd Amendment I need? Yeah. All right. No person shall be elected to the office of president more than twice. And no person who has held the office of president or acted as president for more than 2 years of a term of which some other person was elected president shall be elected to hold the office of once. But the article shall not apply to any person holding the office of president when it's proposed, and shall not prevent any person who may be holding the office of president or acting as president during the term with when this option becomes article blah blah blah, and shall be inoperative. So you can't be elected as president. Yes, technically speaking, I think you could be elected vice president because, well, let me look up another part of the Constitution. It's an interesting, hold on. If the VP cannot become president, what is his power? Technically, president of the Senate. As much power as that gives you, which is not much these days, but there's that, I suppose. You just really like hanging out in the Senate and banging your gavel a lot. I mean, that's cool. Okay. There's a clause somewhere, I think, that says, it's the 25th Amendment that has the other half of this thing. I'm going to say the answer is yes, that the president can be elected vice president, because if the president dies, he becomes president again, but he wasn't elected as president. So I think the answer is yes. Yeah, because the 22nd Amendment says no person shall be elected to the office of president more than twice. And no person who has held the office of president or acted as president for more than 2 years of a term, which some other person was elected, shall be elected to hold the office of president. So yeah, I think technically a former president could become vice president and then could become president again because he wouldn't be elected. I think. No, he can only serve 2 years. That's not what the language says. That's not what it says if you read it precisely. It's not what it says. It's not exactly, no, that's not what it says. Yeah, no, that's not what it says. Very Gorsuch explanation? Yeah, no doubt. I mean, that's, yeah, it's a very Gorsuch explanation. See. Where's it set out? The qualifications be present in Article 2 somewhere? And no person except a natural born citizen, blah, 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 shall be eligible for the office of president. Neither shall any person who is eligible for that office should not obtain 35 years. Yeah, I think a former president could become vice president, and then could serve theoretically an unlimited additional term. He just can't be elected again. So yeah, there's one way to circumvent the Constitution for fun and profit. Who's the greatest president, not counting Washington and Lincoln? My first thought is Thomas Jefferson, for the Louisiana Purchase, which was legally in doubt at the time, and he did it anyway, basically picking up a third of the United States again. Thomas Jefferson might be the best after Washington and Lincoln. Who else might be the best? Yeah, that's probably my pick. How many years can they get? Theoretically, 4 times 15. Although I think the relevant law says they have to be served consecutively. So I think 15. So don't quote me on that. Eisenhower? Eisenhower is a reasonable choice. Reagan? Yeah. Reagan is fine, but I think a little bit overrated in some ways. He's fine. He's a fine president. George Bush Sr. doesn't get enough love, in my opinion. If we're going to talk about like best presidents in George Bush Sr. is an interesting choice for like best in my lifetime over Reagan. I don't think he gets enough love. MLS says 15? Yeah, he's probably right. Coolidge? It's not Coolidge. Teddy Roosevelt. How about that? Teddy Roosevelt's just a badass. There you go. Teddy Roosevelt up in there in the S tier. Teddy Roosevelt is my favorite president. I mean, it's hard not to like the man. Yeah, that's all that comes to mind. Wilson sucks. Coolidge sucks. Yeah, Teddy was a military man. He led an incredibly rich life. He was a military man. He fought wars in Cuba. He, as president, established the national park system. That's pretty cool. And he's Republican, so he's hard not to love for me. Like, you know, conservationist. He once spent, I think, an entire month of his presidency in Yellowstone, which is just kind of cool. I didn't know that was an option, but apparently it was. He just went off to Yellowstone and hanged out there for a while in office. I was like, okay. Edith Wilson was the first female president. Yeah, that's very practically correct. Yeah, that's very practically correct. Teddy Roosevelt was the first U.S. president to get Secret Service protection. That doesn't sound right. That doesn't sound right. Yeah. Since 1901, every president from Theodore Roosevelt on has been protected by the Secret Service. Why would it be 1901? I thought Lincoln signed the executive order for the president to get Secret Service protection the day he died. Am I mistaken about that? 1901 follows the assassination. I'm very confused. Was it called something else before it was called the Secret Service? The Secret Service was formed 1865. So the Secret Service itself was just formed 1865? Instead of the Secret Service didn't pre-exist 1865? So it was just Lincoln signing into existence the Secret Service in 1865? I thought it was specifically for presidential protection in 1865. Okay. All right. And then 1901 is when they gave it to Secret Service to guard the president. Okay. I thought the Secret Service pre-existed Lincoln, but apparently the Secret Service was created by Lincoln for counterfeiting purposes at the time, but still. Yeah. That's what the Secret Service's primary mission. I don't know why they call it the Secret Service. That's a really good question. Why is the United States Secret Service called the United States Secret Service? Why are they called that? Why is the Secret Service called the Secret Service? That's a good question. Okay, so there was a Secret Service inside the United States War Department, which makes sense. But that was just spying. So I'm confused why they're called the Secret Service, completely confused. I don't know. The name is a holdover from the Civil War when the sole purpose was tracking down counterfeiters. Undercover work was important, therefore called the Secret Service. They pre-exist the FBI, right? No. And the predecessor to the FBI, right? Because the FBI, what preceded the FBI? National Bureau of Criminal Investigation and Criminal Identifiers was found. Okay. So basically it's called the Secret Service because at the time it was really the only domestic intelligence service, I guess. That makes sense. So because it pre-exists the FBI, it pre-exists National Bureau of Criminal Investigation, pre-exists the CIA, NSA, pre-exists. So it's basically, I think it's because basically they're the original domestic intelligence service. Okay, I mean that makes sense. Lincoln used Pinkerton. I heard good things about those guys though, man. I heard they were good. Yeah, first undercover force for intelligence, so they were secret because they're spies. Okay, that makes sense. That makes sense. The FBI has a $10 billion budget. The NSA for a while, its existence was secret, which is kind of hilarious. The entire existence of the NSA was secret for a while. Back when it was called no such agency, because it didn't exist. Paper. How's Twitch going? How's the trial going? It's going fine, man. We're having fun over here. We're having a great time. We're learning a little bit about the Secret Service during our break. Sometimes the chat goes in some weird directions. There's been an update of the Maya trial. Last I heard, they were doing negotiations. If anything after that, I don't know. So I don't know. I could check on the Discord, see if there's any information.
Okay.
I remember.
Calling people versus James Crumbley, case number 22279-989, that's the
J Hatch filed a notice of appeal. Well, of course they did. I mean, they do that no matter what, just to preserve their options. I would. Maya's interest up to 2.5 million.
All right, for the jury.
I forget if it was stayed or not during the negotiations. I don't know if the interest clock is ticking or not. I seem to vaguely recall that the interest might have been stayed during the negotiations, but you'd have to go double check the order on that.
Right. you may be seated.
There was an appeal order.
Thank you. Okay, so we were on November the 30th, 2021. This is at 10:39 in the morning. You identified both James and Jennifer Crumbley in Oxford High School.
Correct.
Okay. So this is a surveillance video pulled from that day and that time?
That's correct.
Okay. And the clock there that says 12:42, that's incorrect.
Correct. It never changes.
Okay.
Correct.
So the actual time is in the yellow at the bottom of the video. It just turned 10:40 in the morning.
That's correct, yes.
Okay, thank you. Did you come to learn who this person was that greeted James and Jennifer Crumbley?
Yeah, it's school counselor.
Okay. It just skipped now from 10:41 to 10:52 a.m. Same view, same exhibit. Who do we see leaving the office?
That's the shooter.
And that's 10:52 a.m.
Correct.
Ten 10:53 a.m. Who do we see?
That's James and Jennifer Crumbley leaving.
This is James and Jennifer Crumbley,
Yes.
and they're walking out the counselor's office.
Correct. Back towards the front office.
At one point in time, James Crumbley was holding a white piece of paper. Now it appears Jennifer Crumbley is holding that. Is that right?
That's correct, yes.
Okay. And you just took it back from her?
Correct, he did.
So they leave the building 10:54 a.m. on November 30th.
Correct.
So this is 10:57.
I'm going to
in
go
the
back
morning.
to trying to figure out how I apply for health care.
And let me know when you see James Crumbley's vehicle leaving.
Here it's
You know, I just have to pause 1 second. This is kind of for me here, just a second. because I called the insurance company very briefly on the phone. I was like, hey, by the way, oh, well, it actually doesn't matter because they're having trouble technically. But I'll put it on screen because you can hear me while I'm ranting about this. All right, so I call them. I'm like, hey, I can't find any doctors within 100 miles. They say that's because, we only have doctors in Austin. We don't have any doctors in Houston. And then he said, but let me see what I can do. What's your name? And what's your date of birth? And I actually said to him, well, if you don't have any doctors in Houston and you only have doctors in Austin, and I live in Houston, then every other fact is irrelevant. And he's just like, okay, well, thanks for calling. Have a good day. Because I'm like, it doesn't matter, right? It doesn't matter. You just told me. It's like, I live in Houston. You just told me all the doctors are in Austin, right? So nothing else matters because my date doesn't matter. My date of birth doesn't matter. Nothing else matters because nothing else can change this fundamental information. I don't know. I was mad.
I'm sorry?
Part of it, I'm sorry, yes.
Okay. And so this is just depicting the November the 30th date.
Correct, yes.
36th. And so he logged on to DoorDash at what time?
11.
Okay, so that's the time he actually logged on.
Correct.
Correct? Okay. So going back
I want to
this
know you
version,
mean it?
on Exhibit 142, there are no logons prior to 11 a.m. that day.
That's correct.
Okay. All right. And in fact, you see his first message was 11 a.m.
Correct.
Okay. Exhibit 80, Exhibit 143. Now, the time here at the top corner, that's 11 a.m. to 11:19 a.m. And this is a map that's been created that depicts DoorDash pickups. Is that right?
Correct.
Pickup and delivery?
The route he took, yes.
Okay. And if you refer back to that DoorDash search warrant return, Exhibit 142, you were able to tell that he had 4 different orders that morning until the shooting?
That's correct.
Okay. So this location history depicts what?
Again, that's the path from the Google search warrant return we used to follow the path down to where he picked it up to where he dropped it off.
Okay. And at any point, did he stop by his house?
No, he did not.
This is 11:19. That's when he got his second delivery?
Correct.
Okay. And Exhibit 44, 11:19 to 11:46. What do you see here?
It shows where his first drop off was to where the second pickup was,
Okay.
and then where he dropped it off.
Did he stop by his house then?
No, he did not.
Next DoorDash order is 11:58 a.m.
Correct.
Exhibit 145 here. This is the GPS locations.
Yes, it is from Google, yes.
What do we see here?
His second drop off in the bottom part of the picture to where he went back up to the mire at the top side of the picture and dropped it off.
Did he ever stop by his house?
No, he did not.
This is 12:51 for a DoorDash order, November the 30th. 12:51, that's what you told us when the shooting started.
Yes.
Exhibit 146, what do we see?
Where his third drop off was at the bottom of the picture in the pickup end of the fourth trip and the drop off of the fourth trip.
Did he ever stop by his house?
No, he did not.
Now, what's the first relevant events in either James or Jennifer's devices after the shooting occurred at 12:50?
An email was sent out.
This is Exhibit 141, or a portion of it. This is what?
That's the email header from the Oxford Community Schools at 1:09 p.m.
Your Honor, I believe this is Exhibit 147.
Oh, what did I say? I'm sorry.
It's like 147.
Thank you, 147. So this email was found from a search warrant return in James Crumbley's email?
Correct.
Okay. And it was sent from Oxford Community Schools to james_crumbley@yahoo.com?
That's correct.
Subject line was active emergency at OHS?
Correct.
Okay. And this was at 1:09 and 52 seconds in the afternoon?
Correct.
Okay. Now, were you able to tell him the data location where he was when he received the email?
He was he was going to the mire, yes.
Okay, so this is 1:11 p.m. So 1:11:38 seconds, about a minute and a half later, his GPS pinged at that same mire that you went to?
Correct.
Okay. That's exhibit 148. Now, after that email was received at about 1:10 p.m., who did he call?
He called Ethan.
Okay. He called the shooter?
Yes, the shooter.
And that was at 1:13 p.m.?
Correct.
And at 1:17 p.m., he tried to call him again?
Correct, he did.
Okay. Neither phone call went through, is that right?
That's correct.
It's exhibit 136. Does he leave the Meyer parking lot?
No, he does for a little bit, yes.
Okay. So at 1:17 p.m., we see a lot of different green dots here. Is this the first data location that shows that he left the Meyer parking
Yes,
lot?
it is.
So that was after he received the email and after he called his son twice?
Correct.
Okay. That's exhibit 149. And did he call anybody else at that point in time?
Yes, he tries calling Jennifer.
Okay. That's exhibit 136. And do we know Jennifer left her work that day?
That's correct, she did.
Okay. I'm just going to show a clip here. This is exhibit 150 at 1:18 p.m. So this is after he had that 57-second phone call with Jennifer.
Correct.
Okay, we saw that James left the Meyer parking lot at 1:17. Did he go home then?
Yes, he did.
Now, first, did he receive a phone call from Jennifer?
Yes, he did.
Okay, so this is 1:19 p.m. and how long was this phone call?
10 minutes and 19 seconds.
Exhibit 151 is GPS location from 1:20 in the afternoon, November the 30th?
Correct.
Okay, so that's right after he received that phone call from Jennifer Crumbley?
That's correct.
Okay, and this indicates that he was at the home.
On East Street, yes.
Now, at this time, do we know if Jennifer was on the move?
Yes, she was.
Okay, but she wasn't home yet.
She wasn't home yet? No, she was not.
All right, so this is exhibit 152. Where is she at from 1:18 to 1:20 p.m.?
That's her employer. She, Square Lake and Telegraph, south of here.
Now, while she was on that phone call with the defendant, with James Crumbley, did she send any text messages?
Yes, she did.
This is exhibit 133. What did Jennifer Crumbley write to Andrew Smith? Well, first of all, did you learn who Andrew Smith was?
Yes, I did.
And who's that?
That was her boss at work.
So this is at 1:23 p.m. According to the records that you reviewed. Was she still on the phone with James Crumbley?
Yes, she was.
What did she write her boss?
She said, the gun is gone and so are the bullets. He replies with, I'm praying everything is okay. She says, OMG, oh my God, Andy, he's going to kill himself. He must be the shooter.
Okay. And that was 1:23 in the afternoon on November 30th.
Correct.
Now, did the defendant receive another phone call from his wife after they hung up from that 10-minute phone call?
Yes.
Okay. Going back to the phone log. This is at 1:30 in the afternoon. It looks like a 3-minute phone call between the two.
Correct.
Now, this was at 1:30 p.m. with a 3-minute phone call, so it lasted about 1:33 in the afternoon.
Correct.
What did James Crumbley do after he hung up with his wife?
He called 911.
This is exhibit 154.
Shooter situation going on at high school. My son goes to high school. I'm getting a gun. Need an officer to come to my house. I understand that there's a really tough shit. I have a living gun at my son's school. And we have to go meet with the counselor this morning because something that he wrote on test paper, and then I was in him, and so a whole bunch of cops sitting there, and I made sure I wanted to get to the hospital, so I was on exit, and then somebody told me that there was an active shooter, and I raced home just to find out, and I think my son, I didn't know, I don't know what's going on. It's really tricky now. Maybe Ethan Crumbley, C-R-U-M-B-L-E-Y. He's not here. And to ask him to come in and see if I can do anything for the county work. So, thank you. Okay, Mr. Crumbley. I want to get your name and phone number, and I'll see your brother that's up there dealing with the situation. He's going to contact you, okay? What's your first name? My first name is James. And your last name, Crumbley? And what's your phone number, please? 248-750-6489. Do you know what your son is running out the house for you? He had on something and a green shirt. A green red sweatshirt. Alright. So he's gonna give you a call, okay? I can't give you the time frame because they're right in the middle of all of them. I can't give you a time frame, but we're gonna give you a call so that it's possible, okay? Thank you.
The call was made at 1:34 in the afternoon on November the 30th.
That's correct.
And sir, if you know, that was before the name of the shooter was made public.
That's correct.
Now, at some point, was James Crumbley contacted by law enforcement?
Yes, he was.
Okay, you know if both James and Jennifer Crumbley went to the Oxford, or Oakland County Sheriff's Office, Oxford substation?
That's correct, they did.
Okay. This is exhibits 155 and 156. These are location points. 1:58 p.m. for James Crumbley. Where is he at?
That's the location of the substation.
Okay. So he made the phone call from his house at 1:34, and he's at the police station at 1:58?
Correct.
All right. And this is Jennifer Crumbley. She was there at 1:59?
Correct.
Now, sir, we talked at the beginning of your testimony about the multiple phones that were recovered and that you conducted analysis on. You have a chance to review the forensic download of the other phones as well?
Yes.
Okay. Now, during the course of your forensic investigation, did you find that on a phone associated with Jennifer Crumbley, what we refer to as a burner phone, and an alarm set for December the 4th, 2020?
Correct, it was.
Okay. That's 157. Oh, they're back home at 2:30 in the afternoon at 157. Exhibit 157, is that right?
That's correct, yes.
Okay, so Jennifer Crumbley, 2:30, James Crumbley, 2:30 afternoon.
Correct.
Okay, so now moving ahead to December the 4th. This is exhibits 159 and 160. What are we looking at here?
That's the screenshot on the left side, and then showing the alarm set on the right side.
Okay. Now, from your review of all of the forensic evidence that you had, did it appear that Jennifer Crumbley would leave her phones on throughout the night?
That's correct, she would.
Okay. Now, we talked a little bit about how the cache images were found of that 9mm handgun, but the message wasn't found, and how you have an ability to occasionally obtain deleted content.
That's correct.
All right. Were you able to obtain a Facebook
Thank you,
thread
Kathy, for the
between
$5 super chat.
Jennifer
Your
Crumbley
contributions
and somebody
are
named Brian
appreciated.
Moore?
Yes, that's correct.
Were you able to obtain any particular messages that were deleted?
Yes.
I'm going to show you exhibit 161 and 162. These have been admitted. 161. What are we looking at here?
Going back
The first
to
box
insurance.
indicates that the message was unsent. The second one from Jennifer Crumbley is, "We're on the run again. Helicopters not sure where to message you."
Why are
On
some
December
super
2nd
chats
at
likable?
1:31.
When you say unsent,
I don't know.
why is this significant to
They
you?
just are.
It says she recalled the message back.
And this is from Facebook message?
Yes.
Okay, so this is the
I think
actual
only
shooting.
super chats are
This is
likable, not member
Thursday,
messages,
December the 2nd,
not gift memberships.
2021.
Only super chat
And
messages
sure,
are
we're on
likable.
the run
So.
again. Helicopter
Why that
sent
is, you'd
sure
have to talk to
message.
YouTube.
Correct. Exhibit 162, later on Thursday, December the 2nd, 2021. Did you find another deleted message?
Yes.
And tell us what that is, please.
The original message was, "We're fucked," and then that was also unsent.
And because it says you unsent a message in the red X, does that indicate to you that it was deleted?
Correct.
Now, sir, you reviewed all of the defendant's phone call history. Is that correct?
Correct.
At any point from the time that James Crumbley left that piece of paper on on November the 30th, 2021, to the time the shooting occurred, at any point in time, did he call any doctor, hospital, or medical provider?
There was no indication of that, no.
Now, you reviewed his entire web history as well, James Brown. At any point, did you see him researching 9mm handguns?
No.
The screenshot that was on his phone that was deleted, that was sent from his son to him on November the 8th.
That's correct.
Now, earlier, you described the video that you put together of the shooting.
Yes.
And you spent, I asked you earlier, and I think your response was too many as far as hours. Could you, for context, though, to lay a foundation for the jury, could you give us an idea of how much time you actually devoted to this?
To that particular video?
Yes.
Oh,
Your Honor, I'm going to
40 to
object
50
relevance.
hours.
I'm sorry, I'm going to object relevance.
Judge, the jury's going to see the actual video in a few days. This witness was the individual to put over 100 camera angles together. To do that, he had to watch an awful lot of footage, and he also had to parse out certain activities of students before, during, and after the shooting. The video itself is synced together. There's portions where it skips, and we have to explain why. There's no sound in the video.
Okay, well, you can ask that. You can ask that. Like, it's not one complete video going from beginning to end.
No,
It's not,
a series of different camera angles.
okay.
My insurance rates are going
it's
up a lot.
Followed the shooter's movements.
From the video cameras, correct.
Okay. But you also had to aid in the identification of the victims?
Yes, I did.
Okay. But how is it that you did that?
By where they were
Your Honor, I'm
standing.
going to object to this as well. I don't know how this is relevant either.
Judge, this is a homicide case.
Well, it is a homicide case. I'm not aware.
Thank you. Go ahead.
By where they were standing, I was asked what they were doing just prior to the shooting, the victims were.
So how are you to put that together, though?
I don't understand what you mean.
How is it that you use that information to help identify the other investigators who was who? Let me ask you, did you learn what certain individuals were doing directly before the shooting?
Yes.
Okay.
Yes.
And the group of students you identified as Hannah, Kylie, and Riley, did you know what they were doing?
Yeah, they were just standing there dancing and laughing, it appeared, and joking.
Thank you. That's good.
Can you read Your Honor? Sure. Microphone, Your Honor.
You guys should.
All right, so they're discussing something, whatever it is. Yeah, so it looks like my health insurance rates are going to go up a fortune if I want to keep my current doctor. And if I don't keep my current doctor, then I have to try to find a doctor all over again who will prescribe me the medication I need, and that's going to take several months. I hate my life right now, I really do. How are you all doing? I was feeling pretty good at the start of the day. The alternative is, I don't even know what the alternative is. Looking into concierge doctors or doctors you pay each month and that's your insurance? Yeah, maybe. Can your doctor give you a 6-month prescription? No, it's Schedule 2. 1 month at a time, period. How often do you have to go in? Every 30 days. And every 30 days I have to find a pharmacy that has supply. Because that's another problem with the ADHD medications. Actually finding supply is a whole other set of problems. So every 30 days I have to get a new prescription written. Every 30 days I have to find a pharmacy that actually has supply. And now I'm like, okay, now I have to find another doctor who's actually going to prescribe the medications. That's exciting. Do I have to go in person? No. I strictly speaking don't. So I could just keep the doctor as a virtual doctor and just keep my current plan. Yeah, I mean, I don't have to go. in person. So the only downside to that is I need a mole on my back removed. But it would still be cheaper probably to get that done because I have no either one. I have to go back to either go back to Austin to get the mole removed because there are no doctors in Houston, so I have to go back to Austin to get the mole removed, or I have to pay for it out of pocket. But probably both options are better. So I might be better off just sticking with my current doctor, on my current plan.
We're going to continue tomorrow at 9 o'clock in the morning.
Almost no virtual doctor will want to do schedule 2. Yeah, but he's seen me before, right? So he's seen me in person.
Much like I said at lunchtime, you cannot discuss your testimony.
So he'd only be writing me renewed scripts.
So I'm going to have you.
He knows I exist. We've met.
We start at 9 o'clock.
So he would probably do it.
Right?
But yes, finding a new doctor to do it virtually, good fucking luck. Yeah. Although strictly speaking, he did prescribe it to me. He did prescribe me schedule 2 without ever meeting me. So.
I don't like to make you wait while we're doing.
But he since met me. Yeah, the first time I ever met him was virtual, and he prescribed me schedule 2. So hey, it does happen.
Right. I need to tell you that during the trial, you should read, listen to, or watch the news reports about the case. Under the law, the evidence you consider to decide the case.
Could I get referred to a dermatologist?
For example, witnesses must swear to tell the
You guys are not.
Hold
on.
Because news reports do not have to meet these standards. They could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, do not go on social media, do not post, don't do research, don't discuss the case.
Are they done for the day? It sounds like they're done for the day.
We're going to start up at 9 o'clock tomorrow morning. Does anybody have any questions about the schedule or anything in that? What time do you come today? Well, we'll start at 9, 5 to 9.
The problem is there are no doctors
We'll start at 9.
inside my insurance network anywhere outside Houston.
So, sometimes they, we want to set the camera up. And,
If they're asking me, could he give me a referral to a new doctor in Houston inside another network? Maybe,
So,
but I'm still dependent on.
Social Security, there's all this. So
I'm still dependent on that new doctor doing what my old doctor wants me to do as opposed to jerking me around, which sounds like a gamble to me.
Oh, I forgot to order you to stay healthy. Right? And we'll start again tomorrow then. All right?
All right for the jury.
Yeah, apparently my insurance, apparently the insurance I picked is an insurance company only in Austin. That's where we're at. This was not particularly clear to me at the time I picked it. There would be no reason for me to notice, right? I just was doing a search for doctors and like, oh, there's so many doctors in my area. I was not particularly clear that there were no doctors outside my area, though. That was unclear. So no, there's no doctors in my plan anywhere outside of Austin. Great. That's where we're at. Yeah, it sounds a little tedious. Yeah. Yeah. I mean, when I lived in Austin, I'm like, wow, there's so many doctors nearby. It looks great. And foolish me, I thought being a Texas insurance company, and being on the Texas network, foolish me, I thought maybe it would do business, in other parts of Texas. But apparently not, just Austin.
There are no jury instructions issues anymore, right?
So
No, we agreed a few months ago.
Yes.
what are we doing now? Are we doing a proffer? What are we doing? It looks like we're doing a proffer. Jury instructions debate from pre-stream? It's a little early to be debating jury instructions, I think. And then finding actual supply for my medication is even harder. Last time I ran out, which again, I run out every 30 days. Last time I ran out, I had to call 18 pharmacies. 18 to find one with supply. So, and I can change my insurance plan. I can change my insurance plan because the moving is a qualifying life condition. So I can change my plan, but if I want to keep my current doctor, if I want to both keep my current doctor and find an insurance plan that covers my drug, I'm going from $340 a month to, hold on, $559 a month. So if I want to keep both my current doctor and keep access to my drug, I have to pay another $210 a month in insurance to do it. And I don't have that kind of money because the YouTube game is bringing me in about $40,000 a year, which is, you know, not bad. I can do it on one man, you know, but, you know, it's like, well, I just don't have another $200 a month to be throwing around. I suppose I technically do because I moved, and that would be the differential between my move and here, but, you know.
Would we call this a motion? Is that?
Judge, I think it is. It's an oral.
How much is the medication out of pocket?
I'm just going to place my objection on the record
Why?
that this is being handled.
It was $850
In the middle of a trial.
out of
When this
pocket.
is obviously very likely
think.
going to be put out in the public, Your Honor.
Oh, I do have a concern about that.
Judge, I was not certainly asking for it to be in front of the media, but I don't know how to make a record without that.
Well, we've learned that. It's called 8.119.
May I do it?
Well, I guess I'm wondering, during the course of the trial, if there's any kind of stipulation that could be agreed to.
Certainly, I'm happy to discuss what my request is, Judge.
Well, I'm saying, would you be able to have a discussion with the prosecutor's office? I can't, I have to hold the public court.
Correct, Your Honor.
I do not want to impact your client or your case in any way by doing so. So I'm weighing the rights of the parties. So.
I would be more than happy to speak with the prosecutor's office about this.
Just I'm going to be very brief.
I think the situation could be temporarily taken care of.
What's the issue with the public evidence? Well,
I don't know if that's it.
They whatever the evidence is, there's an issue with its confidentiality, and so if they discuss it in the open, it gets public. So there's a problem.
This is pretty straightforward.
Yeah, Vyvanse, that's the medication I'm taking.
I
Yeah.
know your request is, but I'm concerned about statements that might be placed on the record, right? Aren't I concerned about that?
I am, Your Honor.
I mean, Judge, I think it's appropriate for the record, and obviously the jury's not present, that's why they're not here. But I understand what the court's raising. I'm not.
All right. Well, I know you do. I know you do. I know you understand my concern as well.
I do. Hold on, just 1 second, Judge.
Yeah, the off-brand helps, but even the off-brand was the brand $800 or was the off-brand that was $800?
Another
Either way, I couldn't afford it.
during the duration of the trial, which is about connected. So,
That's exactly it, Judge.
okay, so he's gonna make a new.
I'll probably just keep the doctor. I'll probably just keep the doctor for the foreseeable future.
I provided a draft order, Judge.
There was a draft order provided, Your Honor. It is not time specific. It appears to be kind of a blanket
So,
time period.
Judge,
And I just need someone to take an X-Acto knife and carve this mole out of my back. Any volunteers in Houston?
in fact, Judge, I think we'd be willing to have the order expire by its own terms upon birth. We're just talking about during the pendency of the trial.
I'm shaking this head out. I want to.
Just give me a couple shots of whiskey and we'll rub it down with some rubbing alcohol, and one of you guys can get an X-Acto knife and carve this thing out of my back. It'll be fine.
And Judge, I'm happy to do that.
Okay, Your Honor, my client is not willing to agree to the order.
Okay, so you.
Basically restricting his ability to speak to people. I mean, it's a complete revocation. I have to side with counsel.
I'm not concerned about him being able to talk to you.
Right, and absolutely, that's not part of what we're asking. I mean, Judge, if the order gets entered, we're asking that the communications
check GoodRx? It wasn't any
limited to
better.
only counsel and legitimate clergy during the rest of the trial. That's not a request. We're talking 7 or 8 days. You can talk to the attorney, you can talk to legitimate clergy.
Okay, so if he doesn't agree to it, then the prosecutor is going to make the motion.
And I have advised Mr. Crumbley of that, Your Honor. I would propose that there could be a different order with a restriction and not a complete revocation. Obviously, the prosecutor's office is reviewing communications. They would know whether or not the order was violated, and at that point, if the court needed to take action, then the court could take action.
Judge, it's not just about violations going forward, it's about the conduct that's already happened.
Well, I understand that. I understand that. It's so hard to understand because there's a big old sign right there, right?
Every call. Every single call.
Yeah, I'm
Judge, if there's not agreement, I'd like to just make my motion. It's fairly brief, Judge.
It seems like there was a prison phone call, I guess, that was recorded, and there's an issue over whether it's admissible or not, if I'm understanding correctly.
Your Honor, he is not agreeing to the order.
Okay, well, does he know that in 10 minutes, there was going to be an article about it? Maybe not in 10, maybe 8. I can't, I'm not permitted to have a closed courtroom unless you're proceeding with a closed hearing and reduced from 1 to 9. And as I sit here right now, I don't know if this qualifies.
Yeah, so it sounds like, if I'm understanding, it sounds like there was a phone call made from a prison or jail, as the case might be, that was recorded, and there's some dispute over whether or not that recording can come into evidence. And so the prosecutor wants to discuss the issue, but the only way for him to discuss the issue is by apparently playing the call, at which point the media and us will know about it. So the very act of discussing the thing puts it into the open as they're discussing whether or not it should be put into the open. So that seems to be what they're talking about. Yeah. That seems to be what they're talking about. There's some call from a prison with this guy calling somebody that was recorded, and there's an issue about whether or not it's privileged, I suppose. And the prosecutor wants to make the motion, at which point he has to play the tape, at which point it's in the open. So that's the dispute, I think. Because he mentioned there being big signs on the wall. He mentioned there being big signs on the wall.
Yeah.
And that would be where there'd be big signs on the wall, right? There's big signs on the wall of a jail that say, you know, this conversation's being recorded, blah, blah, blah. Right? So that seems to be the issue. So they're going into the hall to powwow about it some more. And he doesn't want to agree to whatever this order is. So they were proposing an order. They were proposing a order that would preclude the defendant from talking to anyone other than an attorney or a actual priest, a legitimate priest, right? And he can't talk to anyone else other than those people. And for whatever reason, he's like, no, I don't want to do that. I don't want to be restricted. Fuck you, right? I don't want to be restricted. And so they're like, well, you know, I have to make my motion for the restrictions. And part of the reason is because of some call something. Obviously, I don't understand completely what's going on because they've talked about it in code, right? They're talking about it without talking about it. So I'm having to sort of tease it out a little bit between the lines. And the judge isn't particularly happy about having to put it out in the open. So the judge is looking for a solution.
Mr. Judge, I think I can just briefly make a record. This is obviously the order is going to become public. The agreement is going to be that Mr. Crumbley's communications will be revoked, but not his ability to do research or otherwise participate in his own defense. So not just communicating with counsel, but his ability to read or get other information.
Okay.
Simply communication.
And that's going to be a stipulated order between you and this.
Correct.
All right. And did you say that order would expire upon a verdict?
Yes, Judge.
Okay.
And perhaps it should go without saying.
What if there isn't one?
Well, I think,
Would you
I
like?
mean, we can address it at the time.
Okay.
I think the issue is once there's a verdict, a lot of the issues just fall away. And Judge, it should go without saying, but I hope the court will encourage Mr. Crumbley that the conduct that got us here.
I think I already did through his attorney.
Okay.
Thank you. So
Mr. Crumbley apparently did something in some way that somehow was a problem.
The prosecution.
I don't know what that is,
For the record, I've also addressed you.
I know. So
but yeah.
I gave out free legal advice. So someone can take it or not take it, right? So
Can't they
I'll
ask for an
send this
in-camera
together.
review? Apparently not. Right, that was the whole thing. They can only do a sealed proceeding under Rule 8.119 subpart I. So no, apparently they can't do, or the judge doesn't think that this falls into the request for a sealed conference.
May I approach clerk, Your Honor?
So apparently the open records law in Michigan is really, really broad. And so the judge is like, well, I'd really like to do this in chambers, but I'm not sure I can.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah.
All right, so we'll start right at 9 o'clock tomorrow with your cross.
Thank you, Your Honor.
Thank you.
All right. Everyone please have a seat.
All right, well, that is the end of the thing for today, guys. So I guess they reached an agreement on the thing. So I'm not sure what Mr. Crumbley did that got the prosecutors be in a tizzy, but apparently he did something that was not to their liking. And so he's like, well, presumably he communicated with someone other than his attorney or his clergy or his wife. I mean, and who else could he have communicated with? That would be a problem. And there's a couple possibilities. One, he communicated with the press in revealing something that like otherwise was supposed to be confidential. Or he somehow contacted one of the witnesses, which isn't necessarily illegal, by the way, but it's supposed to go through counsel, and he's not acting as his own counsel, so there's some concern that maybe he reached out to one of the witnesses or something. I don't know. I'm obviously trying to read between the lines. One of those two things. And because that's what makes sense. That's your guess? Yeah. I don't know who it is. I don't know who it is. I'm not sure what the discussion was. I don't know what's going on. You know, so I don't know. But we can discuss the rule for a second. Let me see if I can make this a little bigger on screen so that you guys can actually read it. All right, so here's the Michigan court rules, updated 2023. And go back to the thing. Maybe he gave an interview? Yeah, something like that. I don't know what exactly he did. But he did something that was not to their liking. And they were talking about a more restrictive order because whatever he did was not to their liking. And so there's a big pissing match over that. And the judge didn't, it was like, it seemed to me that it didn't seem to me like it was a clear problem. It didn't seem to me like the judge wasn't acting, or she was holding her cards close to her vest if she thought so. But it seemed to me that she thought that the thing that Mr. Crumbley did was kind of marginal, right? It wasn't like, maybe it's kind of like a technical violation, but not like that big a deal. But she's concerned about the future because of whatever it is he did. It seems to be more on the end of like a technical violation than a really substantive issue. Because if this was a really substantive issue, right? If this was really a problem, the judge would just be ruling from on high, you know, banging gavels and, you know, flat flailing people to death. So this seems like more marginal conduct for Mr. Crumbley that was a problem in some way. But they don't want to, whatever it is, because they talked about the big signs on the wall, right? So this call was recorded. So whoever it is, he made a call to somebody, the media, a witness, I don't know. He made a call to somebody and somehow presumably shared information that he shouldn't have shared and blah, 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 whatever. And there was a big pissing match about that. You're so confused? I don't know how I can clarify it any more than that. I really don't know. I don't know how I can clarify it any more than that. How can I clarify it any more than that? I mean, obviously we don't know the details because they're trying to talk about it without talking about it. Because the very act of talking about it brings it out into the open, and they don't want to bring it out into the open. So they all kind of understand what they're talking about. They understand what they're talking about, but they don't want us to understand what they're talking about. So they're being purposely veiled in their language to not let us know exactly what's going on. But, you know, I can use a few context clues to piece together a likely scenario. And so I've pieced together a likely scenario that this would make sense. And then based on the judge's behavior, based on the judge's demeanor, it seems like she's not happy, but she's not pissed. So it's more sort of on the technical violations end of the equation. But she doesn't want to exasperate it by making, because he has the right to be present for the hearing. He has the right to know what the basis of the request is, which means that he has the right to be confronted with whatever his behavior was. But that's in open court, and, you know, the judge isn't super thrilled about doing it in open court because the very act of making it open court makes whatever information he shared with the media, it necessarily makes it infinitely more exposed. Right? Whatever he's done has been contained. And if we broadcast it, it's not contained anymore. The judge said, wait 10 minutes and there'll be an article about it. Yes. Because it would be in the open, right? If this happened, there would be an article about it. Because now it would be in the open and someone would write an article about it. I'd obviously talk about it. So yeah, she's like, look, if we talk about this in the open, if we actually say what we're talking about, there's going to be an article written about it, because of course there is, right? This is some juicy stuff that's being held back. If we actually say the thing out loud, of course there's going to be an article written about it. So she's very concerned that whatever problem has occurred, because presumably the only way this makes sense is that Mr. Crumbley talked to somebody who either is one, a witness, and so there's concern about witness tampering or improper influence, or two, he talked to the media and said things that he shouldn't have said. And either way, this ball is currently contained. Right? It's currently contained to the media source he talked to, or it's currently contained to the witness he talked to. It's contained. But if we discuss it in open court, it's going to be very uncontained, because now everyone's going to know about it. And so the taint of it becomes all the more problematic. Judge said, is he aware an article is coming out in 18 minutes? Yes, she's speaking about the hypothetical. If you go listen, I listened to what she said. I'm quite sure I'm understanding what she said. She was saying that if we discuss this in the open, there will be an article in 8 to 10 minutes. That's what she was saying. Is your client aware there will be an article in 8 minutes if we do this? Is your client aware that this thing that's currently in a containment vessel, is your client aware that by pulling the lever on the containment unit at the Ghostbusters headquarters, are they aware that by pulling that lever, the ghosts will escape and they will suddenly be running rampant through New York City, up to and including writing articles that will be in the press? Are they aware of these things before we, do all that shit? That's what she was saying. It isn't a threat. It's just a reality, because she knows what's going on. She obviously knows what's going on. It's just like, this is a reality. If we say the thing, people are going to write about the thing. So are you sure you want to say the thing? So that's what's going on. You're confused about the situation? Well, yeah, obviously I don't know what's going on, because the entire point is I'm not supposed to know what's going on, and neither are you. We're all not supposed to know what's going on. This has been currently contained into a nice little ball somewhere, and we'd very much like to not open Pandora's box, if you please. No, she wasn't saying that he's aware there's an article coming out. No, she was saying that if we talk about this, there will be an article in 8 minutes. That's what she was saying. If we say this thing, there will be an article in 8 minutes. Faster than that, really, because, me and you are talking about it real time. So it will be instantly, exposed. And she's just like, yeah, if we say the thing, the press will write about it. And then it will become exposed, and everyone will know about the thing. So should we really talk about the thing? What is the thing? I don't know. But we can make a guess. That's what I've done. I've made an educated guess. What is the thing? Well, they mentioned that, the signs. They mentioned there's big signs on the wall. Okay, well, where are there big signs on the wall? There are big signs on the wall at a jail. What does the big sign say? The big sign says your calls are being recorded. Okay, so we clearly talked to somebody on the phone. There's clearly a recording of this. Right? All right, so who did he talk to? Who are the possible candidates? Who did he talk to? Well, the press or a witness, because who else is left? Who else is left, right? If he just talked to, Uncle Larry, okay, so much, so whatever. Unless we're concerned that because Uncle Larry might spill the beans, but maybe we've had a conversation with Uncle Larry. So maybe we're concerned because he talked to Uncle Larry, and Uncle Larry might say the thing. Because, once the thing is, how do you keep a secret among 3 people? Kill 2 of them? Right? Once you tell Uncle Larry about it, maybe he'll tell his friend Tom, who will tell his cousin Steve, and God knows only what happens next, right? So something that is contained has become uncontained, and they have somehow contained it again, and they would very much like to not pollute the world with it. So that's where we're sitting. The signs say your calls can and will be recorded. They just say your calls are recorded and not secret and will be used in all the rest of it. That's what they say. That's what the sign says. So, I mean, you know. And like, if it's a call with an attorney, as to whether or not those are privileged or not, or a call with an attorney, so if they're a call with an attorney or a call with a priest, I don't know how that works in terms of privilege. I've never had that situation. I don't know. I don't know if that works, how that works with phone calls. I honest to God don't know. But because I've never had to think about it, because I've never, been in that situation. What article's going to drop? Oh my God, how much do I have to keep saying it? There won't be an article. There won't be an article now. There is no article. There will never be an article because they didn't talk about the thing. It was a hypothetical. What about this is not clear? I'm very confused where we're losing each other on this description of things. Where am I losing you? I'm very confused. He said something about researching. He wanted the rule that they agreed on to exclude his ability to research. Because the prosecutor's like, well, we want to restrict communications to only his attorney and his priest. And apparently what they agreed to is, okay, he's restricted to only talking to his attorney and his priest, but also he's allowed to do research related to his case. I don't know what the difference between those two things are, but that's apparently what they agreed to. People half paying attention? I don't know. There is no article. There will not be an article. No one is writing an article. Wouldn't the order contain details? No, because the order just says don't do this. The order just says don't do this. It doesn't have to contain any details. No. This says don't do the thing. Here's what you're not supposed to do. Don't do these things. It doesn't have to contain any more it doesn't have to contain any more detail than that. All right. You feel like you're being scolded? It's just like I've explained the same thing 5 or 6 times, 5 or 6 different ways, and people are still like not getting it, or some people are not getting it. And I'm like, where am I losing you? It's frustrating to me as a teacher because I've explained it over and over and over, and it's like, and then people in videos wonder sometimes why I'm so repetitive. Because that's also a criticism people will make in my videos. Why are you so repetitive? Why'd you say the same thing 3 or 4 or 5 times? Do you think we're idiots? All right, so anyways, all right, so here's the relevant rule. Well, stop explaining it. I mean, I'm a teacher. I'll keep explaining it as much as I need to make sure people understand. And I'll try to figure out a different way to explain it. Because I want to teach. And if I'm not clear, I'll try again. I don't know what else to do. I'm trying to be a good teacher. I want to be a good Uncivil. I want to be a good teacher. And I don't want some of my students to be left behind. I'm getting pissed? Yeah, well, I mean, it's not that I'm getting pissed. I'm getting frustrated more precisely. I'm not angry. I'm just frustrated because I'm like, I don't know where the problem is. I'm not sure where the communication's breaking down. That's frustration, not anger. All right, so anyways, here's rule 1.16 that basically says about how we do sessions of court. All right, and then they say, okay, they say access to court proceedings, subsection D. All right, except as otherwise provided by statute or rule, a court may not limit access by the public to a court proceeding unless a party has filed a written motion that identifies the specific interest to be protected, or the court sua sponte, that's on its own initiative, has identified a specific interest to be protected, and the court determines the interest outweighs the right of access. The denial of access is narrowly tailored to accommodate the interest to be protected, and there is no less restrictive means to adequately and effectively protect the interest. The court states on the record the specific reasons for the decision to limit access to the proceedings, which might be part of the problem because the court's like, how do I do that without actually saying the thing? How do I say on the record the reasons without saying the thing? And then another person may file the motion to set aside the order or an objection of entry. And then if the court denies the motion, the party may file application for leave to appeal in the same matter as a party to the action. So any person can object to this and file an appeal. And whenever a court orders limits access to a proceeding that otherwise would be public, the court must file a copy of the order to the state court administrative office. So it's like, okay, that's not great. So basically, and then they say, you know, there's another section dealing with sealed records. Except as otherwise provided by statute or rule, a court may not enter an order that seals court records in whole or part any action or proceeding unless a party's filed a written motion, court's filed made a motion of good cause, which specifies the ground. There's no less restrictive means. In determining whether cause is shown, the court must consider the interests of the parties, including whether there's an allegation of domestic violence, the safety or alleged of the alleged or potential victim, and the interest of the public. The court must provide any interested person the opportunity to be heard concerning the sealing. So again, like the press would presumably get a right to participate in this. Materials that are subject to a motion to seal in whole or part must be made non-public, temporarily pending the court's disposition of the motion. And court records includes all documents and records of any nature filed or maintained by the court. So basically, the reasons that the court can do things in secret is very, very limited in Michigan. The Michigan courts have provided for very open access and apparently somewhat hamstringed the courts when it comes to doing things in secret. Which, you know, okay. I mean, there's costs and benefits to that, and we saw just one of the costs just now because it makes it difficult to have a discussion. Of course, you know, it would still be secret, so, you know, there's whatever. Yeah, there is no article. I'm rude. I'm not trying to be rude, ACB or anyone else. I'm really not trying to be rude. I don't know how to be any... I mean, if you really think I'm being rude, I don't know what to tell you. I mean, I'm trying to explain this as best I can, and perhaps getting a little frustrated that, you know, I'm not trying to be rude. I'm not trying to be belittling to anyone. I'm not trying to call anyone out. I'm not trying to call anyone dumb. Just like, I'm a little frustrated. I'm failing as a teacher. I'm failing. So I'm frustrated at myself. I don't think I'm being rude, but I'm trying to, I don't know how to go about it. I don't know what else to do. Yeah, I'm direct, but I'm not rude. Yeah, I'm very direct. I don't frill around, but I don't try to be rude. I just don't try to hide things. It's like, let me just tell you the thing straight up. Let me just tell you the answer straight up. Like, you know, just communicate clearly. Take a breath, it's okay. Don't feed the trolls. Yeah. Yeah, I mean, I just try to give you the best answer I can. And the court didn't seem to think that whatever the thing is, that the thing qualified for a secret session under the relevant rules. So there's like, well, I don't think we can do a secret session, but I also don't want it in the open. Not a fun place to be in if you're in the court, you know, not a fun place. I'm not sure we can do it in secret, and also I don't want to do it in the open. So what are we supposed to do now? All right? Not fun. Just straightforward? Yeah, it's like, yeah. Yeah, it's like, I'm just straightforward. I don't try to be rude. You know? Sometimes when one of you guys says something like really ridiculous, I'm like, well, that's absurd or ridiculous or you're out of your mind. But I think sometimes it's because you're trying to do it just to get that reaction, but that's okay. Took me a while to understand my style of information teaching growing moment when live sometimes we think frustration's at us. No, yeah, the frustration is like, the frustration isn't me not understanding the problem. Like, where am I failing? Where am I failing in this? How am I not? Where is the breakdown happen? So that I can provide a different way of looking about the different way of explaining it. You know? I'd like to know, is there an amendment that he can research his case and his rights? Well, the best amendment on point would be the Sixth Amendment, the right to effective assistance of counsel. And that goes both ways, because your right to counsel is also your right to, so your right to effective assistance of counsel. One of the things that makes the counsel effective is their ability to talk to you, and also to assist the ability of counsel to assist in your defense. So yeah, there's arguably a Sixth Amendment right to do your own research. I think you can make that case, sure. Breakdown happened because someone came in late and didn't understand the first or second time. That's okay. So that's the best answer I've got for what happened. And, you know, because I can't think of anything else. What did you think? Anna Reed's case, they did not call DLT'd. I don't know. I don't know enough information. I wasn't following it super closely, so I don't have any particular thoughts about calling or failing to call somebody. I missed large parts of the trial because I was moving. Oh, her dad, you mean? Why they didn't call her dad? I couldn't really speak to that. I don't know. Maybe because her dad couldn't help her either. Maybe because there's just no useful testimony to give. You know, maybe because he can't help her as a practical matter. I mean, he's been an armorer right for his entire life, and presumably through his entire life has been, you know, fairly rigorous about safety and things like that. So maybe he just, as a practical matter, can't offer anything helpful to his daughter from his professional expertise. Maybe there's just nothing he can say that would help her. You know? Yeah. Jay's chat? Oh, okay. Do I have to go over to Jay's chat and explain it to people? I can go over to Jay's chat and explain it to people. If Jay's chat is not understanding it, I'll go over there and explain it to them. Hold on. Let's see if Jay's going on. Oh, you just closed? Okay. Well, yeah, I can go over to Jay's chat and explain this rather than us talking between the two. Hannah's own interview really did her in, as always and ever, right? As always and ever, the lawyers continue to try to tell you this, and you guys collectively are not listening to us. Please don't talk to the cops or, you know, pretty much anyone else. They are not your friend. They're not just trying to get to the truth. They're not just doing an investigation. Blah, blah, blah. They're not doing that. And even if they are, it doesn't matter, because you'll still wind up fucking yourself, even if that is their intent. Because their intent doesn't really even matter. They might genuinely just be searching for information. They might genuinely not consider you a suspect. That can change depending a lot on what you say. Yeah, so please don't talk to the police. You know, it's amazing. Oh, you know, it's the jury's favorite thing. It's the jury's favorite thing in the world. Juries eat it up all the time. There is simply nothing better in this world than statements from the defendant's own mouth. I think that's true. I think statements from the defendant's own mouth are, in the end, more powerful than DNA, video, fingerprints, eyewitnesses, like everything else. There is just nothing more powerful, because people are under this impression somehow, for some reason they believe, well, if it were me and I were innocent, I wouldn't say anything that could possibly lend to convict myself. I wouldn't say anything stupid. It must be because they're guilty. Only a guilty person would say this. So everyone is collectively a moron, because everyone collectively believes that, you know, if it were them and they were innocent, then surely they would talk to the police, because, you know, I have nothing to hide. It's all going to be okay. And I won't say anything that hurts myself. And, you know, well, basically it all goes to shit. But the attorneys keep trying to tell you this. It's like, look, there is nothing better in this world. And there are cases, and we've seen cases where, in my opinion, there wouldn't have been a trial, let alone a conviction, without the testimony. For example, the nurse who was convicted about 6 months ago or whatever it was at this point, she gave the wrong medication, right? She gave completely the wrong medication to a guy. He comes in for one reason, and she winds up giving a completely different medication that's a very strong paralytic. It's a very strong paralytic that has, you know, danger, caution things all over the hell, all over it. You know, danger, paralytic, don't use, you know, super duper danger, whatever. And basically, I think mainlines it right into him, into her IV. And wouldn't you know it, it like stops the guy's heart or whatever. So that's pretty bad. That's a pretty big fuck up at the office. But I am fairly convinced that that trial does not happen and she is not convicted, which she was convicted, but for her talking to the investigator. You know, and you just watch the tape and you're like, oh my God. And you just watch it and just like, you just mark every time, like in your own mind, you just mark every time she basically fucks herself. And it's like, it's just, you know, and it's a 45-minute discussion. She just fucks herself. You know, you are not smart enough, you are not clever enough, and you're not innocent enough for that matter. You're simply not innocent enough. Because you never know what the police think, what they might believe. Even if you are in fact innocent, you don't know what information you have that is in fact, you are in fact innocent, but, you know, you never know what the police are looking for. You never know what you could say that might trigger a thought in them that you're the guy. Because you don't know what they're looking for. You know? So it's like you don't even know. But yeah, I mean, of course her own words do her in. Her own words are the thing that do her in. Does she get tried without that? If she said, you know, I'm invoking my right to remain silent, does she still get tried? Who knows? Does she still get convicted? It's a harder case for the prosecutor, isn't it? It's a lot harder without that testimony, isn't it? It's a lot harder than without her words, you know, basically slicing and dicing. It's like, I'm a super responsible armorer. I know all the things. I'm really trained. I'm really good at my job. I believe in safety. Right? She just walks right off the cliff. So, does she get indicted? Does she get tried? Does she get convicted without that testimony? Who knows? Right? I mean, your confession can only hurt you. It can't help you. Right? You may be doomed anyway. But there's just nothing to be gained by confessing. Maybe the police have enough against you. Maybe you are guilty and maybe the police have enough. And maybe you're going down. But, you know, if that's the situation, there's nothing you can do to stop it anyway. Right? There's not some sort, if they really have that much against you, right? If they really know that you're the guy, right? I mean, it's not like you're going to somehow say something that's going to be like, oh, okay, you know, we had all this evidence and we're ready to convict because it's so strong. But from your magical words, you know, from your words that are just so persuasive, man, didn't we have this all wrong? All that evidence to the contrary. Wow, what idiots are we, right? There's just no way. You're not good enough. No one's good enough. No one can pull this off. You know, it just doesn't work. So just invoke your right to remain silent. It's really easy, guys. I keep telling you this. It's super duper easy. All you have to say is, I want a lawyer. I want to remain silent. And then here's the key, actually remain silent. That's it. I want a lawyer. I want to remain silent. Don't overcomplicate it. Don't say any other words. Don't. Just just keep it simple. This is really easy. I want a lawyer. I want to remain silent. It's all of 9 words long, guys. I know you can do it. Just do that. That'd be great. And if the cops tell you you're under arrest, then, you know, and you can't leave, then you keep your mouth shut. You know? They're going to arrest you, they're going to arrest you, right? If the interview is the last step before they're going to arrest you, if they're going to arrest you, they're going to arrest you. They're going to arrest you anyway. So you weren't going to convince them, you know, if they brought you into the interview room for a interview, right? But not arrest, but they were planning on arresting you, right? They walked into the room with the intention to arrest you at the end of the interview because, like, we have enough stuff, we're ready to go. But you know what? Let's give it a shot. Maybe we can get some more stuff from this guy before we actually do the arrest. So it's like, hey, why don't you come down to the police station? We just have a few things to clear up. You know, all the while the police are ready to arrest you if you say no. Like, you know, if they walk into that room and they're like, we're going to arrest you, there's nothing you're going to be able to say that's going to prevent them from doing that. There's just no way. It is not happening. Don't even try. Don't even try. You actually technically do have to say the stay silent part. You actually do have to say it. Which I know is a little contraindicated, but you do. I mean, strictly speaking, technically, yes, if you actually did remain silent, then yes. But the thing is, you can't do that. Because one guy tried to pull it off, and he made it for about 12 hours before he gave up. So one guy tried it. He didn't actually say, I want to remain silent. He actually just remained silent. And I forget how long he lasted. I have to go double check the case record, but it was a long time. It was like 6 hours or 8 hours or 12 hours. He actually remained silent for a long time until eventually he started talking, and then he confessed, and then he was done. And because he never actually invoked his right, the state allowed the U.S. Supreme Court allowed that confession in because he never actually invoked his rights. So yes, you actually have to say, I want to remain silent, which I know is a little bit contraindicated or a little bit silly because you're having to speak to remain silent, but those are the rules. Just deal with it. A night in jail beats years in prison. Preach. Yeah. I remember reading a case. I remember reading an article about a guy who was arrested for self-defense in his home. I think Ian talked about it. So I might have learned about it from Ian's stream. But either way, there was a guy who was arrested for self-defense in his home, and it was a perfectly righteous self-defense, and he invoked his right to remain silent. And he was kept in jail over the weekend, 3 days or whatever it was. And then, you know, come Monday or whatever it was, when, you know, he had the opportunity to go to court and he had a lawyer, his lawyer explained, you know, how this was clearly self-defense. And the judge is like, oh, okay, never mind, case dismissed, right? And apparently the cop who arrested him came to him and said, I really wish you had said that to me. I wouldn't have arrested you in the first place. And I'm like, yeah, but I mean, we know that after the fact, right? We know that after the fact. But in the moment, yeah, I don't know what you would do or wouldn't do. It's like, yeah, you think that now, you wouldn't have arrested me. You wish I had said it now. But I don't know, man. The guy might have been the sharper edge for it. I mean, he did have to spend 3 days in jail for a completely righteous self-defense. I mean, the guy broke into his home and the whole 9 yards. I mean, it was self-defense. It was self-defense all day long, right? There was no complications about it. It was self-defense through and through, and he did have to spend 3 days in jail. But I don't know, man. I mean, 3 days is still a lot better than him saying the wrong thing and being on trial, and God knows what happens. So I'm not even sure the guy was wrong, even in retrospect. Is an attorney charging you $1,000 an hour excessive? It depends on what the attorney is doing. It also depends on where they are. So it depends. It depends. Like, what is the attorney doing? What kind of business? What kind of attorney is he? There are attorneys who charge $1,000 an hour. I mean, typically you're talking about, you know, white shoe law firms like in New York City. But you can get $1,000 an hour. You can get $2,000 an hour depending on, exactly what your attorney was doing. I was looking up Paul Clement's rates recently because there was a guy who contacted me and said, hey, would you represent me before the U.S. Supreme Court? I was like, okay. So I had to write up a retainer. And so I was like, well, where am I going to get my retainer from? I was like, well, I'll just steal it from Paul Clement. That seems like a pretty good idea, right? I'll just steal Paul Clement's retainer and rewrite it for my own needs. Which, incidentally, by the way, I've said this before and I've said it again. Plagiarism is not a sin in the legal profession just as much as a pastime. We plagiarize the absolute shit out of each other, and we do it all the time. It is not a sin. It is just a pastime. So, yeah, we absolutely rip the absolute shit out of each other all the time. Anyways, so I had to write a retainer, and so I stole Paul Clement's and used it for my own purpose. And Paul Clement's charges a flat fee. He charges it in 3 stages. And the first stage is $150,000 to get to effectively file the brief, to file the cert petition. To file the cert petition effectively is $150,000. If the merits are granted, then it is another $100,000 for the merits brief. And then it's another $500,000 to actually get him to effectively argue the case. So for Paul Clement, to get him to do your case is $750,000. Is Paul Clement worth $750,000? He's pretty fucking good. It's like, I'm willing to do it for $350 an hour. So my projected costs are probably in the low to mid 5 figures by the time I'm done. Paul Clement's over here charging $750,000 an hour. I'm like, yeah, I'll charge $350 an hour. By the time I'm done, assuming we get all the way through the merit stage and everything, you're probably looking at expenses in the low to mid 5 figures. So, but Paul Clement is Paul Clement, and I'm not. So Paul Clement can charge 15 times what I make, what I'm earned. So it's like, Yeah. Yeah, you're a retired legal secretary? Yeah, right. Copy paste, right? Yeah, we just plagiarize each other. Plagiarism is just how we roll. Yeah. That Neil Cattell bails $2,500 an hour? Yeah, I mean, there are attorneys that are like that. So it depends what your attorney is trying to do. Who are they? Where are they in the world? Are they a senior partner? Do you want the partner's time? If you want the partner's time, that's going to cost you a fortune. Right? The associates are typically a lot cheaper. If you want a partner to do it, it's going to be like, big bucks. Are they a full partner? Are they a full partner in a New York law firm? Have they been working for 20 years? Yeah, maybe $100,000, maybe $1,000, maybe more. It could be good. I'll do it for $350. It's pretty reasonable, right? Yeah, your law professor says no need to reinvent the wheel. That's right. That's right. Just take what someone else did and rewrite it. Yeah. That's the Supreme Court, not small claims. Yeah. Well, the easiest way to figure out if your attorney is overcharging you is to look for comparables from other attorneys. That's a really good way of doing it, which you really should have done anyway, particularly if you're going to spend $1,000 an hour. You should probably be looking at what other attorneys who do that work in the town that you're looking at, what they charge. You should be looking at 5 different firms if you're going to lay down that kind of money. And figure out, so I mean, that's the best way to do it. How much are your rights and freedoms worth? Well, as has been said before, freedom isn't free. Sometimes you have to protect your freedom by going to literal war. Sometimes you protect your freedom by laying down your life. Sometimes you protect your freedom by hiring an attorney to defend your rights. Freedom isn't free. It costs. It costs lots of things. So, one good way of answering the question, one good way of answering any question of how much is something worth one good way of answering the question is, well, how much are you willing to pay for it? Right? That's a really good way of determining what something's worth. How much are you willing to pay for it? I mean, something's worth only as much as you're willing to pay. If people aren't willing to pay it, it's not worth it. So how much are you willing to pay for your rights and freedom? How much are you willing to lay down for it? What price are you willing to pay for your rights? How important is it to you? You know, so it's like, well, it's pretty important to me. So it's, you know, it's worth a lot. So yeah, I'm willing to, you know, you have to pay for it one way or another. That's part of the deal. Popcorn Planet is rating me? Fantastic. Yeah, hello, Popcorn Planet people. We're just sort of wrapping up and doing legal analysis and legal discussions. I don't know if any of you guys have any questions, but I'll answer them as best as I can. Thank you, by the way, for joining me. Thank you to the 35,798 of you who are currently following me on Twitter, which incidentally is a very good way to get notifications of my streams. So since sometimes YouTube doesn't send them out, you can be one of the 35,798 people who get notifications by, you know, Twitter. That works too. What's with the Clemson thing? Well, I mean, again, I would just simply say, think about it. What do you think the Clemson thing is about? But it's my undergraduate. It's my undergraduate school where I got my undergrad degree. Go Tigers. What do you think it's about? Yeah. Popcorn Planet people. Thank you for coming by. I got the notification. What else can I answer for you? What other legal questions can I answer for you about this case or other cases in the news? Supreme Court stuff? What's on your mind legally that I can answer? What would you ask, let's say, Sonia Sotomayor if you got to meet her? If I met Sonia Sotomayor, I'd treat her with the absolute utmost respect. And I would say that, you know, I don't know what question I'd ask her, but you know what question I'd ask her? If can I be your clerk? That'd be good. Can I be your clerk? How about that for a question? Can I work for you? Oh, that'd be good. Yeah. Why am I so addictive to listen to? I think it is my voice coupled together with my knowledge and wit. I think that's why I'm enjoyable to listen to. Plus, the microphone and sound settings that I've put in place to help make the microphone sound nice don't hurt either. You're terrified about the immunity thing? I don't know what the answer is on the immunity thing. I really don't know. I'm really looking forward to covering the merit briefs in the near future. Because I want to know what the answer is too, for my own sake. I want to know what the answer is, and I don't know what the answer is. I thought that one of the judges at the DC Court of Appeals asked a really good question. DC Court of Appeals judge asked, okay, if the president orders SEAL Team 6 to assassinate his political rival, is there absolute immunity for that? Because I mean, he is issuing an order to the military. He is commander-in-chief, and the military, let's presume the military carries this out. And incidentally, by the way, this has nothing to do whether or not we can charge any of the members of SEAL Team 6, by the way. We may or may not be able to charge them. That's another day. That's another question. But let's assume that let's assume they carry out the order. Let's assume they carry out the order and shoot and kill his political rival. Okay, can we charge the president for that without impeaching him? And Trump's lawyer said no. He didn't really say no, but he's like, it's a qualified, can we charge him? Well, it's a qualified yes, if he's impeached first, which is basically just saying no. But he won't say no. It's like, yeah, he has to be impeached first. I'm like, well, I'm not sure if that's the right answer. That doesn't sound right to me. You know, what if it just so happens to be that the president and his party, you know, are currently dominant in Congress? What if they like the fact that the president killed his political rival? You know, what if they don't impeach him because they're concerned about getting killed themselves? I don't know. It's like, can we really not charge this guy without impeaching him? Seems like an odd conclusion. I thought that was a pretty good point. So I'm very much looking forward to reading the merits brief so I can figure out what it is I think on the issue. What do I think? Do I think he has immunity or not? It's like, I'm not sure. It's a good question. I don't have an answer to that question. So since I don't have an answer to the question, I don't know what I think, and therefore I need to read the merits brief so I'll know what to think. I think it's an interesting case. You can absolutely share the link for Richard Hogue. Yeah, dump that in chat and we'll share that. He must be impeached. See, I don't know if that's true. That's the whole thing. And I haven't taken the bait. Well, that's not, first of all, that's just not fair, Matt. That's just not fair. That's just not fair to me. I just told you I thought it was an interesting question because it results in this answer that doesn't seem right. That's what you do in law all the time. That's what you do in law all the time. You come up with hypotheticals to test your conclusion. That's what you do in appeals. You come up with a hypothetical and you say, okay, you say the president's immunity is absolute except for impeachment. He has to be impeached first. If he's not impeached, he cannot be charged. Is that what you're saying? And you say, yes, that's what I'm saying. Unless he's impeached, he cannot be charged with a crime. He must be impeached first. That's the only way. I'm like, okay, well, so let me ask you this hypothetical. And then I ask you the hypothetical. And you're like, wait a second. That would mean that the president can't be charged for the SEAL Team 6 assassination, except unless he's impeached. That doesn't sound right. That doesn't sound right. That sounds wrong. So therefore the question has now successfully challenged the premise, right? It's like the conclusion that should flow, right? President is absolutely immune, except for impeachment. President has ordered SEAL Team 6 to kill his political rival. SEAL Team 6 has in fact killed his political rival. The Congress of the United States has not impeached. Well, what does deductive logic tell you? Deductive logic tells you, therefore, QED, it must be true that the president is immune. And then at least you come to me and I'm like, wait a second, that doesn't sound right. That doesn't sound right. And so you have basically proven, or at least suggested to me, that the premise is wrong. The very premise I started from is wrong because I followed it in deductive reasoning all the way through and I reached a conclusion and I'm like, that conclusion doesn't make sense. So effectively proved by contradiction, my premises are wrong. Now, I'm not willing to go so far as to say they are wrong. I'm willing to go so far as to say, wait a second, there is a problem here I can't solve. There is a problem here I can't solve because I have an obvious contradiction right now. I have an obvious contradiction. I can't believe all these premises at the same time and believe this conclusion is wrong. If I believe the premises, I must believe that the conclusion's right, but I think the conclusion's wrong, so I have a problem. And I gotta fix the problem somewhere. And so I'm exploring it. I'm exploring it through thought. That's what you do. That's how you think. That's literally how you think. You test your thinking. You test your presumptions. You test it. And what do you really think? Do you really think that? And I'm like, I don't think that. It just seems wrong. Now, maybe it's correct. Maybe it is correct. Maybe when I think it all the way through, maybe when I read the merit briefs, maybe when I think it all the way through, maybe when I read enough information, maybe I'll come to the conclusion, you know what? Actually, it turns out all my premises were correct. The president is absolutely immune, and if Biden orders the assassination of Trump with SEAL Team 6, and the Democrats refuse to impeach him, then Biden cannot be charged for that act. So Biden can assassinate Trump. And maybe that's the correct conclusion, but I'm not willing to reach that conclusion right yet, so I have a contradiction that must be resolved. You know, that's how you do. That's literally how you think. That's literally how to think. What happened in the Crumbley trial? It's over for the day. And now we're just hanging out and answering questions. Will we ever get cameras in the Supreme Court? I'm doubtful, and I'm also not sure we gain anything by it, to be quite honest. I don't know what we gain by having cameras in the courtroom. We already have audio recording, and it's released same day. I just don't know what we'd gain by the visual. I just don't see the point, to having the cameras there. I think it would actually take something away from the experience. But that's just me. Maybe some people don't understand the word hypothetical. I don't know how to deal with that. Yeah. So yeah, please vote for Richard Hogue by hitting that shared link. We do like to support Richard Hogue. If I'm doing politics, I'm out. Crimson Berry, strictly speaking, I was not doing politics. I was doing law. I was not doing politics. I'm doing law. There is a substantial difference to me. I was doing a legal analysis. I wasn't doing political. I was doing a legal analysis. It's not political. Not to me. It's a legal question. It's a straight legal, it's not political. It has nothing to do with it. It's like, it would be the same if it's Trump, by the way. It's the same answer. If suppose Trump gets an office. If you don't like me asking the question, if Biden assassinates Trump and the Democrats refuse to impeach him, can Biden be charged? If you don't like me asking that question, no problem. We'll change it. Let's suppose Trump gets elected. Let's suppose Trump orders the assassination of Biden or Gavin Newsom or Nikki Haley or AOC. Let's suppose President Trump gives that order. Let's suppose SEAL Team 6 actually kills all those people. Let's suppose that the Republican Congress refuses to impeach Trump. Now Trump's out of office. Can we put Trump on trial? Can we? It has nothing, it's not partisan. It's not partisan. It's a pure question of law. It's not political. I just simply asked the question because Biden happens to be in office in the moment. It had nothing to do with Biden. It could be anybody. It could be literally anybody. It has nothing to do with Biden. It's about the office of the president, whoever happens to be at the moment. It could be anybody. Can anybody do it? Could I do it? I'm suddenly president now. Don't worry about how it happened. I just am. What's the rule? What is the rule? It has nothing to do with politics. It's about law. It's all about law. It's a very broad hypothetical. Maybe it is a broad hypothetical, but it's the hypothetical to test the point. It's the hypothetical to test the point. It's like, do you believe it or don't you believe it? It's like, and I'm like, I'm not sure. I don't know. Because I thought I believed in absolute immunity, and then you asked me a question. I'm like, I don't think I believe in it anymore. I'm not quite ready to give up the belief. I'm in the questioning stage, but I recognize there's a contradiction. I recognize that I literally have a pure contradiction in logic. I have a pure contradiction in logic. I have a whole bunch of premises. The conclusion that flows doesn't seem correct. If the conclusion that flows doesn't seem correct, then the premises must be wrong. So something is wrong in this equation. And I'm not sure what it is yet, because I haven't made up my mind. I'm thinking. I just simply recognize that there is a problem. There is a contradiction, and I haven't solved it yet. Yeah, so that's what it's all about, man. What law exists currently that says the president has any immunity? Well, the idea would be that that he has immunity inherently from the nature of his office. It is a silent constitutional aspect. The Constitution doesn't say it, but the idea is that it's inherent, and that certainly has been sort of the dominant thinking that's inherent. So that seems to be the dominant thinking, but now that thinking is questioned because it's like, wait a second. When we actually go apply that thinking in the real world, or at least the hypothetical real world, we run into problems. But the other option, the reason why I can't give up the belief yet is because the other option seems to be, well, the president doesn't have absolute immunity, and therefore the president can be charged. And that raises a whole host of other problems. Because if the president can be charged with crimes, well, I mean, it's like, you show me the man, I'll show you the crime, as they say, right? You show me the man, I'll find you the crime. It's like, the president of the United States, all of them in recent memory, arguably are violating the War Powers Act. How about that for a start? Now, whether or not the Wars Power Act is constitutional is another discussion, but let's move past that for the moment. It's like, it's like, if the president doesn't enjoy absolute immunity, then that raises a whole host of problems. What are we really saying? Are we saying that any of the 94 federal prosecutors, or perhaps any of the God knows how many, the 3,000 or so county prosecutors that are out there, are we really saying that any of them might be able to bring a charge against the former president as long as they can find a jurisdictional nexus? That seems like absurd nightmare fuel. That seems like we're just going to be winding up charging every single president for the rest of time, kind of like South Korea, which has been doing that. We're going to charge literally every single president when they leave office, because it's basically impossible to not violate some law, and the motivation to find a law to charge them with is extremely high. Of course you want to go after your political rivals. Why wouldn't you? It's glorious. It's great, right? So your motivation to find something, anything, is pretty high. So if the president doesn't enjoy immunity, then it seems to run into a situation where we're endlessly indicting the president, federally and or statewide. Some county prosecutor somewhere can find a jurisdictional nexus, and suddenly we're off to the races. And that doesn't seem like the right answer. That's the kind of thing they do in third world countries, right? So it seems like he can't have immunity, and also seems like he must have immunity. So it's like, well, how the hell am I supposed to deal with that? How the hell am I supposed to deal with the logical contradiction that he can't have immunity, but he must have immunity? How am I supposed to make that circle square? And I haven't figured out the answer yet. I don't know the answer yet. Yeah, whether or not SEAL Team 6 could be brought up on charges is irrelevant to this current discussion, because the immunity that exists would be in the office of the president. So whether or not SEAL Team 6 could be charged with a crime is irrelevant, because no one is arguing SEAL Team 6 is immune. We're only arguing about whether the president is immune. So can SEAL Team 6 be charged with murder? Sure. But that's not the question. The question is, can we charge the president? Yeah, it's like when people want to charge W with war crimes. Yeah, you could probably charge every president with war crimes. Maybe not Trump, but every other president you can charge with war crimes if you're so inclined. Yeah, so it's a really interesting problem, and I don't know the answer yet. So I'm really excited to read the merit briefs on the issue, because the merit briefs will provide me argument on the merits, and maybe if I'm a really smart Uncivil, maybe I'll be able to figure out the answer, irrespective of what the Supreme Court does. Maybe I can figure out the answer. That'd be nice. If I can figure out the answer, I haven't figured it out yet. Being smart enough to know what you don't know is always helpful. Being smart enough to realize you don't know the answer yet is helpful. And being humble enough to say, hey, I don't know what the answer is. I thought this was a really good question. This really good question creates a logical contradiction in my mind. I have a logical contradiction. This is no longer logical. I can't make it work. I like to make it work. I want to be logical. I can't make it work right now. How can I fix it? How do I fix it to make the logic work? And I don't know yet. Yeah. No one State of the Union. It's a waste of my time. No one State of the Union. I think it's a waste of my time. Do I live in Texas before? Well, I've lived in Texas for the last 3 years. I lived in Austin for that time. Did I move there because of the Supreme Court request? No, I moved there just for a change. I moved there just to try something different. And then I moved to Houston to be closer to my friend. Yeah. This is what critical thinking looks like, right? This is exactly what critical thinking looks like. This is how you do it. All right? It's like you actually try to follow your logic all the way through, and then it's like if you run into a contradiction, like, wait a second, this doesn't work anymore. I'm gonna fix it. The SEAL Team 6 hypothetical seems like they could just plead orders. Again, we don't have to worry about it. You don't have to worry about whether or not you can charge SEAL Team 6 right now. That's not the problem. Don't worry about it. Just assume that you can. Just assume you can charge SEAL Team 6. Don't worry about it. Okay? It's not the problem you're trying to solve. We're not trying to figure out whether or not we can charge SEAL Team 6. Assume the answer is yes. Assume we can charge SEAL Team 6. Can we charge the president is the real question. I mean, the whole premise is, by the way, of course, the president ordering the assassination of his political rival is illegal. And clearly illegal at that. Manifestly illegal. So SEAL Team 6 probably should be refusing an unlawful order, but they didn't. So we are where we are. You know? Yeah. Yeah. I mean, the entire premise of the thing, of course, is that him ordering SEAL Team 6 to do this is illegal. Otherwise, it doesn't make sense. No. We're assuming that the president ordering SEAL Team 6 to assassinate his political rival is illegal, which seems like a pretty reasonable assumption. You know, so if it's not illegal, then the president doesn't need immunity because it's not illegal. So so that's one way to say it. Well, if you conclude the president ordering SEAL Team 6 to assassinate his political rival is actually a legal thing to do, then we don't have to worry about immunity, because immunity from what? Although that's very uncomfortable, because then again, Biden or whoever the president happens to be can order the assassination of Trump or whoever the political rival happens to be, and apparently that's totally okay. So that doesn't seem like the right answer. That doesn't seem great. Oh yeah, Biden can order SEAL Team 6 to kill anyone he wants, and apparently it's never illegal. I mean, that's a solution to the problem, but it's not really a great one. That doesn't seem like that can be the right answer, does it? That doesn't seem like the right answer. With SEAL, so the president Redick, he didn't tell us, but he thought it was implied. If SEAL Team 6 is doing things based on what they think the president wants, based on implications, they're fucked. Because you know, in order for it to be in order, it has to be, you know, in order. So if SEAL Team 6 is, well, yeah, that's good. Yeah. The reason we blew up the embassy is because we thought the president wanted us to do that. I mean, he didn't tell us to do it or anything, but you know, he was mentioning how mad he was at Russia, and he was mentioning how mad he was at them and how their diplomats suck, and we read that, and we decided that we're going to blow up the Russian embassy all on our own, because it's what the president would have wanted. Yeah, that's going to go real well at their court-martials, I'm sure. Courts-martial? Courts-martial. Yeah, the other way around, not court-martials, courts-martial. Yeah, I wouldn't recommend that. I didn't want to mention Russia. It doesn't matter. Pick any country you want. It was just an example. The president's been railing at China recently. You know, the president's been talking about China and, you know, the Hunter Biden stuff, and we thought the president wanted us to blow up the Chinese embassy because, you know, we were concerned about protecting the president from the Burisma shit. And we did it because we thought that's what he wanted. You know, last time that Finland was in town, the ambassador said that he didn't very much like the green beans the president served him. And we know how much the president likes green beans. And we interpreted that as an act of war. So all on our own, we've decided to attack Finland. Throw in your own hypothetical here. It doesn't. Russia is just an example. It doesn't matter. Yeah. Who will rid me of this meddlesome priest? Yeah, I really don't think SEAL Team 6 deciding to kill someone because the president says, who will rid me of this meddlesome priest, is really going to be very effective. You know, for them. I'm not really seeing that be, yeah. We thought that's what he wanted. That's definitely how the military works. The military definitely goes on innuendos and hence as opposed to orders. That definitely sounds like something SEAL Team 6 would do. My board is weird. Yeah, it dropped X stats. Yeah, that happens, Matthew. From time to time, it happens that it decides that it doesn't like me very much and decides that for some reason I don't exist as a user. So, but I appreciate the super chat. If a political rival's on death row and the president doesn't pardon him, well, that's fine, right? That's fine. Because that's the president. Because the president has no duty. The president has no duty to pardon him. And we're assuming that his political rival's on death row for, you know, actual legitimate reasons in this hypothetical. So this political rival is in a federal prison because otherwise the president can't pardon him. And we're assuming that he's in prison because he was justly convicted of something that warrants the death penalty. And the president doesn't pardon him. Yeah, that's fine. He doesn't have to pardon him. That's fine. That's fine. If they had a speech expert that specialized in dog whistles, again, I'm not sure. I've never been a member of SEAL Team 6. I know it's hard to believe, guys. I mean, you know, you take one look at me and be like, damn, Kurt, when were you in SEAL Team 6? Why aren't you wearing your trident right now? I know, I've never been a member of SEAL Team 6. It's very hard to believe, but it's true. But yeah, I don't think that's really how they operate. I just don't think that's what they do. Too smart for SEAL Team 6? I reject that. There are a lot of smart people in the military and special forces in particular. There are a lot of smart people in special forces. Oh yeah. No, I reject that completely. There are a lot of smart people in SEAL Team 6. I have no doubt in my mind. I have no doubt in my mind there's a lot of smart people. He asks too many questions to be in SEAL. Yeah, that'd be good. Yeah, I'm in Buds apparently, and I'm asking questions of my sergeant. Wait, no, it wouldn't be sergeant because it's military. It's the Navy. What is the rank of the drill instructor in the Navy? Whatever. Yeah, I don't think questions is really what they do in the SEAL Buds thing. I don't think that's a thing. Master Chief? There you go. Master Chief. Yeah, yeah. I did see the, I think it was Discovery when they did they filmed an entire Buds class. I think it was class 234 they filmed. Holy shit, dude. So I did watch that. It was a great series, by the way. If you've never seen it, it's really good. So they got a camera crew to actually film the entire Buds training from beginning to end. I mean, presumably not the entire training, but you know, definitely a lot of it. And they filmed it and they displayed it. I'm like, holy shit. And yeah, it looks like a lot. It looks like a lot. I took a look at that. I'm like, you know, I don't really think that's for me. I think that being wet and sandy all the time would really get to me. I'm not really feeling the SEAL team thing. I'm not really feeling having sand constantly up my butt crack is really for me. I don't think I'm a SEAL, guys. I don't think that's the life for me. Maybe some other special forces, but you know, probably not the SEAL team. I'm 43 now. Also, it probably doesn't help with the SEAL team. I'm not sure. I mean, the military has been, you know, relaxing its requirements for a little while now, but I'm not really seeing them bringing the fat, out of shape 43-year-old who can barely run into the SEALs. Not really seeing them doing that. That seems rough. I think that's probably not going to happen. Also, I would die, like, just immediately. Although we did watch that. Remember, we watched that recently with what was the guy 54 who went to boot? That was badass. That was so cool, right? So, yeah, that was a great thing we watched. The guy's 54 years old. He had previously been in the military, and then had retired, and then for some reason I don't remember, decided to re-enter the military, and so they made him go through like 4 different physicals because he's like 54. And the recruiter tells him before he signs the paperwork, he's like, you know, there's been a change, by the way, in the rules. So you're going to have to go back to boot. I mean, you've previously been in the military. You're still like, you're honorably discharged and all the rest. So you have rank, but you have to go back to boot. And he's like, really? And it's like, yeah. So you wind up with this 54-year-old. I think he's Marines. Was it Marines? It might be Marines. You have this 54-year-old guy who's back in boot, and apparently he graduates something like the top 10% of his class in terms of like his physicality and stuff, which has just got to be the biggest blow. If you are, you know, a 20-year-old, right? You're a 20-year-old and you're getting your ass smoked by a 54-year-old in boot. That's just rough, man. That's just rough. So, hey, maybe if the 54-year-old guy can survive in boots, maybe the 43-year-old can go to SEALs. Maybe there's still hope. Yeah. Maybe there's still hope. Yeah. So, yeah. But I'm pretty out of shape, guys. I don't really think... I'm pretty out of shape, and I can't really run from here to there, and my pull-ups are not so great. So I don't think the SEALs are for me. And I don't think the Green Berets are for me because I don't really like their mission. You know, Green Berets tend to go somewhere and then like stay there for a while and do like ongoing development or ongoing whatever. I don't really think that kind of mission's for me. So I think Green Berets are out. How about Special Forces Air Force? What do they do? Maybe I could get in on that. Maybe I can get myself in on Special Forces Air Force. How about that? That might be good. All right, I think I'm going to sign off now because we've been talking for a while and been having fun. But I don't think we have anything more to talk about. So I think I'm going to land the plane now. But I've been having fun talking to you about these various subjects. It's been enjoyable. So we will be on tomorrow with more of this, I anticipate. And depending on your interest level, we'll keep going. So as long as we have, you know, enough participation, enough super chats and everything, then we'll keep covering it. If not, then we won't. But I think we'll go tune in for tomorrow. So we'll tune in for that. Probably we won't do Thursday night Thunderdome tonight because we've got the trial tomorrow and I need sleep and stuff. And also my mods would like a break. So all that. And we'll see you guys tomorrow. Until then, I've been Uncivil Law. Is there anyone I can throw you to while I'm thinking about it? Because I always forget to set it up until I'm literally signing off. So I've somehow Pavlov's tricked myself into remembering exactly when I sign off. Who is streaming? Is anyone streaming? I can send you Nelly, the lawyer chick, for an upcoming stream. Is anyone else streaming today? No one is streaming. Okay. Yeah, no one is streaming. Not in my queue. Danny isn't streaming. Yeah, Donnie isn't streaming. All right, I'll send you to an upcoming stream. I'll send you Natalie Lorchick stream. She's streaming at 6:30, so I'll send you that way. All right, I'm going to sign off for now, and I hope all's well. Cheers, my friends, until later, and goodbye.